hello, hello. I'm waiting on Sprinkled Donut to come on in just a minute. How you doing, Cinderella? So glad to see you. We're going to talk about a really weird case today that we came across, and I am like shocked that this could ever really happen because I've heard of something like this before, but I never believed it. You tell me, how in the hell does somebody sit before they're convicted now? Check this out. 10 years before the guy actually gets his conviction for he gets on death row. There's just some facts of this case that's so damn weird. And so once my friend gets up here, we can start talking about it. But the name of the case is called the Lucky Ward case. And I was so shocked when I came across this. I hope you're doing well today, Cinderella. Good to see you. I need to. Well, my phone's about to die, which I need my phone. But anyway, let's plug this in. Let me make sure that. What are you doing? No. Oh God. Why is it doing that? Let me get my camera back on. Hang on. Whoops. There I am. Okay, sorry. I'm like, oh, no. But why is it doing it again? No. Come on. I want to be right there. Okay, I'm on. Now, so what in the world is it doing? Okay, I don't know what's wrong with this camera here, but I hope I don't have to. What is it saying? Your browser has what? No. Okay, well, it's disconnected my camera, so I guess I'm going to be like this today, so sorry about that. It's okay. We'll just do what we got to do. It's fine. Anyway, so the name of this case is the Lucky Ward case. I'm just waiting on our friend Sprinkled Donut to come on in. I just sent her the invite so she can come on in, but maybe should I do it from here too? Let's see. Copy. I don't know why my camera doesn't want to work right, but okay, it's all right. We'll just deal with it. Anyway, there we go, in case anybody needs that. All right, good. So the name of the case is Lucky Ward, and I'm going to go back to the very beginning on this case, and we'll talk about him for a second, because you hear little things every once in a while. People say, well, somebody sat on death row for 10 years, or somebody was in prison for 10 years, or somebody was this, that, the other. But guess what? Not really true. But in this case, yeah, he was. So let's pull him up right quick. Oh, come on. Lucky Ward, come on. The thing about this case is this little guy was just a homeless guy, right? So we're talking about, okay, so there's a bunch of little things that happened in this case that I feel like was somewhat motivated by the fact that he was a poor, homeless man. And so he did not get the same level of help that somebody else would get in the same circumstances. And that really did upset me. So I'm going to go back into, this goes all the way back. Now, I'm going to read a story that is actually from a couple of years ago. This was from November the 5th, 2010. That's kind of how far back we have to go on this particular case. So, Houston, Rietta Long, 52, was strangled, and they want to know if the suspect, Lucky Ward, is responsible for the deaths of 2 other women nearby. Lucky Ward, who himself is homeless, is charged with capital murder in this case. However, police told us Ward has not been ruled out in the murders of 2 other women who also died downtown as well. Now, this is not in some podunk city. This is Houston, Texas. Okay. So, as the bell rung at the Co-Cathedral of Sacred Hearts downtown today, there was a new reason to give praise. I'm sure many people will feel a little bit more at ease, said Jenny Faber with the Archdiocese of Galveston in Houston. More than a month after Rietta Long's body was found on the steps behind the chancery of the Archdiocese, police announced the arrest of a suspect. Personally, yes, I do feel a sense of relief and gratitude, and it was a significant concern, obviously, for many of us. This is Faber speaking. It was DNA evidence, police say, that linked Ward, 46, to the murder. A homeless man who was arrested just a few blocks from the murder scene. Ward reportedly confessed to strangling Long over what was described as a petty argument. Police say during the crime, Ward stole the victim's Metro bus card, ID, and other items. A lot of these this is the police speaking now. A lot of these homeless people, they carry everything they have in their bags. So even an ID that is worth nothing, maybe for them, is a lot. Lieutenant Humberto Lopez. All right, here she goes. Here's our friend.
I'm
There you
sorry. I was putting
go.
groceries away and I got distracted.
It's okay. My camera
and then
was
I
working and now it's not.
and
So,
I started to make coffee and the coffee maker wasn't working and I'm like, what's going on? And then I needed water. It was just a big old thing. Yeah, it was just a big old
it's
thing.
okay. Well,
Yeah.
we're happy you're here. So I was just reading the story from 2010 about how this started with Mr. Lucky Ward. So now, although Ward and Long were both homeless, it's unclear the extent of their relationship. We do know that Ward did seek refuge at a downtown homeless center, a place where another victim, Carol Flood, was known to frequent. Her body was found behind the old YMCA building at 1600 Louisiana on October the 10th. Police say Ward is considered a suspect in Flood's murder as well as the murder of 24-year-old Raquel Mundy, who was last seen alive at the Greyhound bus station downtown. I would consider him to be the prime suspect, but he's somebody that we're looking at, says Lopez. While Ward's arrest signaled a sense of relief for those troubled by the crime, it wouldn't change what happened. It was a memory that will stay with many people who work here every day, and it will certainly be with us for some time, says Faber. Police told us that the suspect had yet to be questioned about those two other murders. DNA results expected in at least 2 weeks. Ward is being held on no bond. He is due in court on Monday. Lucky Ward has a lengthy criminal history dating back to 1984 when he was convicted of stealing money. Some of the other charges include aggravated assault in 1985 and 2006 of criminal mischief drug possession and most recently a prostitution conviction in 2007 for which he spent 2 weeks in jail. Ward has a lengthy criminal history dating back to 1984, which is double that. Oh my God. Yeah, it has the same paragraph twice. Okay, we'll skip past that. But anyway, so that is his original. This is from 2010. Well, then the case moves forward a little bit. So now we're going to go to the next thing that kind of happens. So let's go back to Lucky Ward. What's interesting about this case is when we're going to watch the oral arguments that happen in the Texas Criminal Appeals Court. And when we start watching, you'll be going, oh, wow, it's going to tell you a lot of things about this case. It's pretty damn interesting. So let me go back over here and pull this other part up. Lucky Ward. I have pictures of him and everything else, but let's find something from, hang on just a minute. So I'm going to go to Justice Courts. Come on. Open up, open up. It doesn't want to open up. Now, there is a 33, let's see, how many pages is it? Let's see. It is, oh, that's three. Okay, let's pull it up over here so we can actually see it. So let me hold on. Let me go out here to the internet. We'll pull this up. So Criminal Appeals Court, Texas. Okay. Okay. Now we're going to pull up Lucky Ward. Here we go. All right. We'll pull this up first. We're going to look at his brief first and discuss the things that they're saying went wrong in his case. So, oh come
He
on,
had
I
a
know it's
horrible and he had a
he
horrible
did.
childhood. I mean,
He
his
sure did.
dad drug him behind a car chained. I mean, when he was like what, 11?
Well, read that part while I pull this up.
I have to go back to Wikipedia. I
Yeah,
read
because we
that
need to find his
earlier.
actual document here. Lucky Ward, come on. I
I'm
knew it
gone,
was in here. I saw it.
Wikipedia. Yeah, it was
Lucky
bad.
Ward.
I mean, just terrible abuse as a child, and it was just horrible. I mean, and he
Okay.
admitted to the one murder. It wasn't like he was like saying, um,
Okay.
yeah, Lucky Ward was born November 1st, 1964. He grew up in an unstable home where he was physically and mentally abused. His mother gave him to her brother, who was known to sexually abuse children when he was a baby. His uncle raised him until he was 7. He later spent some time with his violent father, who once dragged him behind a car to which he was chained. These
Mm.
experiences affected his mental health and led him to be diagnosed with schizoaffective disorder and bipolar disorder. At 14, he sexually assaulted an 83-year-old woman. He was arrested and confessed the same day. After
Isn't that
spending two
something?
years in juvenile prison, he was released at 16 and sent back to his abusive father, despite a recommendation that he may not be returned to his mother. That sentence doesn't make sense.
Well,
Soon thereafter, he was accused of assault, tried as an adult, and sent to adult prison at 16. He was released in 1985 after being sent back to prison in 1985. He was in custody of the Texas prison system until 2006. And upon being released, he became homeless and addicted to drugs.
isn't that terrible how that happens? Okay, let me turn this back over here. I mean, a lot, times have changed quite a bit because, as y'all know, like many years ago, well, up until recently, just a few years ago, I mean, anybody with a felony, you weren't getting a job. They were getting out of prison, they weren't going to have a job. Okay, what did they expect these people to do? Well, then they started making some changes, in the systems where they would actually help these people once they got out of jail, go back into the world, like they get to a halfway house, and they get them jobs and help them acclimate back into the world, right? And that's great. But a lot of these old timers, they never got that opportunity. And I've always kind of thought that was kind of unfair. Yes, we know you did something wrong, and that's okay, right? We know that. But what we don't have to do is make them never be able to be in normal society again because that's just not so. We believe in people to get second chances, right? Even people who sadly take the lives of others should have maybe a second chance as long as the circumstances. I mean, there's a lot of factors that go with that. I'm not saying everybody, but I'm saying some people do deserve to come back into our world and be given a second chance. So,
Well, as long as they've served their time,
right,
and they do not exhibit any mental conditions, and it looks like they're going to be ready to acclimate back into society and have remorse, and there's all those boxes that need to be checked in order to do that.
right.
But
I agree.
dumping somebody out of prison onto the streets, what is that going to do? That's going to do nothing.
Right. How are you helping them? You're not. So what? I mean, what was the whole? Prison should be. It is a form of punishment, but it's also what else do they consider it to reform people, right? That is to reform
Rehabilitation.
and punishment, rehabilitation. So, but I don't really see where a lot of these people actually get any rehabilitation, which I find very, very sad.
Well, I think part of the
Go ahead.
part of the recidivism rate with people in prison and in jail is so they can have a place to live.
Right. Right.
They're like, I don't want to be on the street. I'd rather be in jail, get a few meals a day, have a place to live. So they'll commit another crime to go back in.
That is so sad. Well, I've heard that too. All right, so I'm gonna start over here on page. Let me see what page I'm on, guys. On page 12, because when you look at the front of the appeal, the brief, you'll see all this stuff that we don't. I'm not gonna really read all that. We'd be here forever. So we're gonna start on the introduction page, which is actually page 12. And we're gonna talk about this. So it took 2 years and 7 months. Now listen, this is not normal. 2 years and 7 months for the state to file its response brief after numerous extensions and blown deadlines. This is ridiculous. It should not have happened. Even after this court's multiple indulgences, the state's brief is riddled with factual and legal errors. Wow. We endeavored to correct as much as possible in this reply, but a few of the numerous reversible points of error, POEs, bear special emphasis. First, the indictment here required the state to prove that the homicides of two very different victims committed at very different scenes under very different circumstances were nevertheless part of the same scheme of course of conduct. Lucky Ward confessed to causing Rietta Long's death, but to get a capital murder conviction, the state also had to prove beyond a reasonable doubt that Ward had killed Carlos Rodriguez, a charge that vehemently he denied that. The lack of an eyewitness placing Ward at the scene of Rodriguez's death made DNA evidence of paramount importance. The SB repeatedly claims that Ward's his pubic hair was found on Rodriguez, which is totally false. Ward was expressly excluded from the only results of DNA testing of pubic hair found at the scene. He was excluded. It was not him. The state has otherwise exaggerated or flat out distorted the tenuous evidence linking Ward to Rodriguez. Second, during the state's weak guilt phase presentation, the trial court admitted over the defense objections extensive evidence of an unadjudicated extraneous offense, the murder of Carol Flood. The state's efforts to connect Ward to Flood's death were even more strained than with Rodriguez's offense. Rule 404B was completely contorted and to admit this improper and unfair prejudicial evidence. Third, this is the very interesting part when we start talking about Ward's mental health, because when you watch the oral arguments, you're going to hear something about mental health and it's going to shock you. You're going to be, how does that happen? It should never have happened. It was completely wrong. But here we go. Ward's mental health history is irrational behavior clearly required the trial court to hold a separate trial on his competency. Now, this is where it gets weird. In an attempt to justify why the trial court did not do so, the state relies on a case decided years before the statute governing competency assessments, Chapter 46B, before this was enacted. The state compounds this error by claiming that Ward's counsel waived his right to a competency trial. But it is the trial court's duty, not the defense counsel's conduct, that is at issue. The failures with which respect to the duty led to Ward being improperly excluded from virtually all substantive pretrial proceedings, critical portions of voir dire, and much of his trial. That should never happen. Fourth, all the trial was delayed for years as the state sought evidence to support its assumptions that Ward was a serial killer and that blatantly revealed it had mishandled a great deal of evidence. The court insisted on rushing to the finish line where the defense was plainly entitled to a continuance. The defense demonstrated the obsolete need for this continuance, supported by sworn affidavits. After the state sprung results from the novel DNA testing obtained using experimental technology for analyzing complex mixture of biological samples, just as the trial was starting. Okay, you can already hear by what we're saying here the many mistakes, errors, and just flat out trashy. They did not do justice to this defendant, to this system. They just made a mess out of this case. The trial court inexplicably refused to pause to obtain essential experts, and then, based on no more than this distinctly shaky evidence, allowed testimony about yet another murder into the punishment phase. Any of these sets of egregious errors require, at the very least, a reversal. And here are the corrected facts to this case. As the court engages in its independent review of the record, a note of caution is warranted. Despite having an exceptionally long time to study the record, State's counsel makes numerous material misrepresentations about the record, endeavoring to distract the court from the huge distortion of Rule 404B and POE 5 through 7 is something they're trying to quote over there. The state claims that the circumstances surrounding Rodriguez's death and the injuries that she or he sustained were the same as those as Long and Flood, SB 38 and 54, which is the little, remember the little information above all this? That's where you would go look at that. This is incorrect. The state's own evidence, the Rodriguez autopsy report, includes a trauma analysis of Rodriguez's neck, the only site of the injury, which concludes that characteristics of the fracture are consistent with a compression of the neck and affected only the anterior arch of the carotid cartilage. The report notes that other aspects of the neck as atraumatic, showing minimal tissue injury. Elsewhere in its brief, the state claims incorrectly that the death of Rodriguez, Long, and Flood were all obviously similar, yet somehow utterly distinct from numerous other strangulations that occurred in Houston, including those involving only neck compression. But the medical examiner expressly found that Rodriguez died from a neck compression with minimal external injuries, as opposed to Long, which had a ligature strangulation with blunt force injuries to the head and torso. And Flood had a ligature strangulation and blunt head and neck trauma with extensive external injuries, including to her head and genitalia. How is that the same? It's not. No external anything, just neck compression versus these two other. No. Also, the state misleads the court regarding the evidence linking Ward to Rodriguez. The state repeatedly refers to a pubic hair recovered from the sheet where Rodriguez's nude body was found, falsely claiming that this pubic hair was Ward's. And then we're not going to read all these little, we'd be here all day. But Ward was expressly excluded from the only pubic hairs associated with Rodriguez's crime scene that yielded DNA profiles, identifying only one pubic hair item, described as pubic hair, possible tissue, as well described as hair, possible tissue. Also, the only trial testimony about this pubic hair and a DNA analysis was the admission that one pubic hair and one potential pubic hair had yielded two unknown male profiles from which Ward had been excluded. But they used it anyway? You tell me how that happens. Unfair. So here's the question. Okay, moving down to 24.5.2.1, which is a pubic hair lifted and the tape lifted from the sheet. Once again, this was a single source of DNA sample, meaning it wasn't a mixture. The answer was yes, correct. Question. And is this the one or associated with unknown males, meaning you didn't have a sample to compare it to, correct? Answer is, it means I did have samples to compare it to, but the samples did not match any of those. Okay, question. Lucky Ward was excluded from that, correct? The answer was correct. And the question is next. The pubic hair was not tied to him. Now, the item in 24.5.4.1, hair from the tape lifted from the sheet, this was where you got another single source of male DNA to an unknown male number 2. Once again, meaning you compared it to a sample you had and it didn't match any of those. The answer is correct. See, listen to what it's saying, and there's, oh my God, I feel like the guy was railroaded here. State's counsel on appeal is replicating a deception perpetrated at trial when State's counsel repeatedly made misrepresentations about the DNA evidence in its guilt phase. The closing argument. State's counsel falsely asserted that he left hairs, including pubic hairs, all over Rodriguez's body, to which defense counsel objected because there were only 2 hairs, not hairs, all over his body, and there was no pubic hair attributable to Ward at all. But this did not deter the state. It again mischaracterized the evidence, suggesting the testimony was pubic hair. He was all over him. He's all over him, and nobody else is all over him. Nobody else is even so much as on him. Yet the state's own evidence showed a pubic hair from an unknown male was indeed over Rodriguez, as was other potential pubic hair from yet another unknown male. This false characterization about this pubic hair, however, was repeated a third time in the state's closing, as the state insisted that Ward should be found guilty of murder, for which there was no legitimate evidence of his guilt. I'm telling you guys, as I read this, it makes me sick, because I know that what they're doing right here, let me just come up here. I know that what they're doing right here is unfair, and I'm not going to tell you what happens in the end, but anyway, had this guy been somebody without a public defender, he would have not been railroaded like this. That's what I think about this case. It's horrible what happened. This is a miscarriage of justice. It should have never happened this way. We'll keep reading. It makes me ill. The state plainly recognizes the probative value of a DNA profile pulled from a pubic hair from a sheet in a case where the victim, Rodriguez, had died during or soon after rough sex, and where Rodriguez's body was found under that sheet. But the state obscures the piece of the highly probative evidence yielded as unknown male DNA profile. And no effort was made to determine to whom that pubic hair belonged once Ward was excluded. Instead, the state lied about this pubic hair at the trial and now does so again in this appeal, pretending that this significant piece of evidence inculpated Ward when in fact it exculpated him. The state also exaggerates other aspects of the scant DNA evidence, purportedly linking Ward to Rodriguez. What was admitted into evidence were 2 partial single-source DNA profiles from 2 hair fragments, and while Ward could not be excluded from the potential profile, the resulting probabilities of them belonging to some other randomly chosen, unrelated African-American male was exponentially more likely than would be true with analysis of a full single DNA profile. But even assuming that this non-pubic hair belonged to Ward, they could easily have been transferred from Ward to Rodriguez during their encounter in a parking lot where Ward offered to watch her car. Rodriguez flirted with Ward and took his picture, and then Rodriguez posed seductively as an unidentified person and took Rodriguez's picture as she was wearing scant clothing, hugged her car. Okay, so this is the victim and this is Mr. Ward. That's, you know what? This is interesting. I'm going to tell you something. So, I mean, we've seen a lot of briefs and things like that, but I've never seen pictures in a brief. This is kind of amazing. They're actually showing the pictures. All right. Here we go. So, The state also dramatically mischaracterizes the DNA test results related to the flood crime scene. It was flood crime scene and what can be inferred therefrom. They're comparing SB 67 through 67 with SX 478A. Unpacking the full scope of the state's distortion with respect to the issue would require extra record evidence and proper indirect appeal. But the state potentially just ignores actual trial testimony from its own DNA analysis, who admitted that the only testing that did not finally exclude Ward, done 5 years after the initial investigation by a private lab, is not very probative, and within the field of DNA analysis, it's considered a last resort. You see, send it out when you don't get the answers from the state, you send it out someplace else until you get the answers you want. That's what it seems like to me. The analysis admitted that the single test results that seemed to link Ward to Flood's car, based on Ward's DNA profile, showed only that he could not be excluded as a possible contributor to a mixture from multiple contributors. And even though only using the inexact YSTR analysis, a YSTR assessment would never allow an analysis to say that the resulting partial DNA profile belongs to a person for the state's own witness. Additionally, while the state admits, as it should, that Rodriguez's roommate, Sosa, repeatedly described the man he saw the morning of Rodriguez's murder as a bald black man who looked strong, the state distinguishingly urges that Ward fit that description. SB 41. Homeless, drug-addicted Ward was not bald and strong looking in the photos that Rodriguez took. Let's take a look. Does he look bald and strong? No, he does not. Okay. That's my thought. So, oh my goodness, it's ridiculous. All right, let me go back to where we were. And here's another picture. Well, so then they show it again. Here's the picture. Similarly, the state falsely suggests that Rodriguez's neighbors, let me put this where you can see it, reported seeing no strange vehicles at Rodriguez's house to counter evidence that the defense had adduced about the uninvestigated motorcycle man photographed outside Rodriguez's house, who was black as well as bald and strong looking. Okay. Here, this is our look at Lucky Ward. Here's his picture. Now let's go down. This is the guy that was never identified that was seen outside Rodriguez's home. They do not look the same. Not at all. Take a look. Am I going too fast? What do you think, Sprinkle? They don't look at the same at all, do they?
Not even close.
Not even close. Okay. The investigators admitted at trial that they never canvassed Rodriguez's neighbors to learn anything, including whether a black man or any man had been seen leaving Rodriguez's house the morning of his or her death. There was no testimony of any kind from any neighbor. Likewise, the state misrepresents the importance of evidence related to Rodriguez's silver and brown purse. Sosa initially told law enforcement that he had seen these two purses in the house's bathroom after he interrupted Rodriguez having sex with a bald, strong-looking black man, but the purses were not there when Sosa returned a short time later after searching for some kind of work. Plainly, Sosa was trying to create a narrative that a black man had killed Rodriguez and stole those purses. But later, investigators found that Rodriguez's silver purse inside Rodriguez's car, with cash still in it, lying beside Rodriguez's digital camera. And the brown purse was later found in a closet, finding the purse that were never really missing. Rightly cast further suspicion on the roommate, Sosa, who seems to have seized upon the tiered trope of thieving, the big, strong black man, to divert attention from himself. The one falsifiable component of Sosa's self-serving tale about the missing purses was falsified. And this is just one of numerous reasons to doubt virtually everything Sosa reported. But the state urges believing that Sosa's story about the purses, which requires imagining that the silver purse with its cash somehow moved from the house's bathroom into Rodriguez's locked car, and that the brown purse moved from the same bathroom to a closet during the brief window after Sosa supposedly left the house. And Rodriguez died, and Sosa returned to discover Rodriguez's body around 9 a.m. Sounds fishy, doesn't it? Sounds real fishy. It is uncontested that Sosa lied to the police about sexual relationships with Rodriguez and about how Sosa had come to live in Rodriguez's home rent-free after Rodriguez had picked up Sosa at a gay bar. Sosa plainly lied about the migrating purses too. Police rightly did not believe Sosa's tale about the bald, big, strong black male either, until a month later. A black man who was neither bald nor strong-looking confessed to an unrelated crime, explained that he had mental problems and had been off his psych meds, and produced his crack pipe while explaining his addiction issues to the detective interviewing him, and then broke down sobbing. It is hard to imagine an easier fall guy for various unsolved murders of a various low-status victim. The state's contorted efforts at trial to try to rehabilitate Sosa did not legitimize law enforcement's decision to pin Rodriguez's death on Ward, absent evidence. Nor do these efforts amount to evidence supporting the conviction. These efforts merely expose the Threadbar case and show how Ward was scapegoated after he confessed during a police interview to causing Long's wholly unrelated death. I can see what happened here. The state admits at one point that Rodriguez's camera, date stamped, was off, but then pretends that the chronological sequence of various photos can nonetheless be ascertained. No one at trial claimed to be able to know the chronological order of the photos that law enforcement eventually downloaded. Rodriguez's camera included numerous photos of men with whom Rodriguez had sexual encounters, drag shows, fashion ideals, and an array of other things. How Lucky Ward's picture ended up on Rodriguez's camera was explained entirely and credibly by Ward himself. But the state insists on an unsustained chronological order to support an invented narrative and then impugn Ward's credibility, voluntarily statements to police about how he had come to contact with Rodriguez, whom he believed to be a woman, and how she had taken his picture in front of Rodriguez's new Montero. After Ward's statements, this is incredible. At her new Montero, after Ward had offered to watch her car in hopes of receiving a tip. I can see that. Ward's involuntary statements are wholly consistent with the photographic evidence, whereas the state's contorted narrative requires discounting everything Ward said, except his admission that yes, he was the person in a photo pulled off of Rodriguez's camera. The examples recounted here are just some of the state's many distortions of the record. Wow. So let's look at these points of error. Point of error number 1. The evidence was insufficient to support the guilty verdict because no rational trier of fact could find Ward killed Rodriguez. Point of error number 2. Ward's right to due process was violated because no rational trier of fact could find beyond a reasonable doubt that he committed the charged offense. Point of error number 3. The trial court erred in denying the motions for directed verdict because the state's same scheme or course of conduct explanation is unsupported by the record. And point of number 4. The same scheme or course of conduct language is applied renders the phrase in Texas Penal Code, there's the number, unconstitutionally vague. All right. The state has a credibility problem, and I will agree with this. As outlined above, skepticism regarding the state's summary of purportedly inculpatory evidence is warranted. A sufficiency of evidence review cannot be based on false facts and invalid inferences. Okay, there's the next statute they're going to go by, but I'm not going to read all that. Describing the standard and acknowledge that even some of this damning as a defendant's bloody prints found at a murder scene do not constitute direct evidence of the ultimate fact to be proved, but are circumstantial evidence that must be considered with other circumstantial evidence admitted at trial. The great lengths to which the state now goes to misrepresent the state's trial case must be rejected. The same scheme or course of conduct element was not satisfied. This is interesting. When challenged at trial, the state could not even explain the same scheme or course of conduct that it supposedly just proven. Now, in its brief, the state fails to provide any legal justification for its serial killer theory. The state incorrectly argues that some loose similarities between two murders are enough to show the same scheme or course of conduct. The state's reasoning means that any two crimes of the same general category could satisfy this aggravating element, rendering the statutory text as nullity. The state's own cases readily expose the overreach. It is absolutely an overreach in my book. Coyne versus the state found a regular mode or pattern of behavior existed where the defendant on different occasions had abducted women, driven them to remote areas in his truck, raped them in front of the seat of his truck, strangled each of them with ligature, and stabbed each one of them in the torso, Moreover, evidence presented in the punishment phase that he had committed similar abductions, sexual assaults, and stabbings before and after the charged offense. Okay. Garcia versus State involved evidence that the defendant within 2 days had sought out the exact same type of victim, a taxi cab driver, and killed each deliberately by shooting them 3 times in the back of the head. All right. So, the legislative history shows that it was meant to capture serial murders, with one lawmaker citing Henry Lee Lucas as an example. Ironically, since the virtuality of each of the hundreds of cases attributed to Lucas, mostly as a result of his confessions to Texas Rangers, have unraveled, showing that this symbol of the serial killer seems to have been little more than a very impaired man susceptible to suggestive interview techniques. See? All right. Maybe we should watch the Netflix story about Henry Lee Lucas that talks about that and shows the confessions of a killer. It is on Netflix. Gonzalez versus State. All right. Explained that the defendant had targeted women over very specific demographic types: Hispanic, middle-aged mothers. His pattern was to start intimate relationships with them, subject them to abuse, and then kill them through blunt force trauma to the head. Thereafter, he disposed of their bodies in open, vacant areas. All right. In each of these cases in which there was no sufficiency of evidence challenge, the same murder was essentially committed twice. Far more analogous to this case is Oldham versus State. In Oldham, the court found the same scheme or course of conduct element was not met because the murders of 2 individuals were animated by similar motives, not the same or similar systematic plan. The defendant shot and killed one man who had accompanied him in an attempted robbery, and later that day killed a second man who threatened to call the authorities. Thus, even though the state had argued a common thread of criminality, including the use of the same gun, an excessive number of bullets fired each time, and a relationship between the victims, which were roommates, that was insufficient, the court found the similarities did not amount to the same scheme or course of conduct. It therefore reformed the judgment and remanded for a new punishment trial. Okay. The case law is clear that proving the same scheme or course of conduct requires far more robust similarities than is supported by the state's evidence or briefing. Neither of the circumstances nor the mode of the Rodriguez's and Long's offenses were the same, and the victims were decidedly different. State has audacity to argue that because Hispanic, homosexual, physically fit, biologically male Rodriguez liked to dress like a woman, the victims were both essentially female. But Rodriguez was nothing like Long in terms of demographics or lifestyle. Rodriguez was a fun-loving partier with enough income to go out almost every night to clubs, to provide a house rent-free to 2 other men, Sosa and Cruz, to own a new SUV, and to have numerous possessions distributed over several households. Long was a mentally ill middle-aged African-American woman living on the streets with 1 bag of possessions, estranged from her family, with her only known attachments being to men's similarity down on their luck, like Ward or Robert Osbury. The state argued in its guilt phase closings, we don't have to prove why, but that is part of the same scheme does require. And it's perhaps why the state second later invented a motive based on nothing. Maybe the defendant can't ejaculate and he takes the rage out on women. Just stunning. Not only did the state adduce no evidence to support this wildly inappropriate speculation, it is based on, number 1, false assumptions. Oh, did you fall out? Hang on. Where are you? Did you fall out? Where are you at? Hang on. I was just reading along and didn't even notice. Okay, are you there? Okay, there you go. All right, back on. There you go. Now, see, this is ridiculous. It's like they're just making up whatever they can and throwing it in there and see if it sticks. Just throw it in the wall. If it sticks, we're going with it. That's what it sounds like. Oh my God. Not only did the state adduce no evidence to support this wildly inappropriate speculation, it's based on, number 1, the false assumption that Rodriguez was a woman, and number 2, the assertion that Ward had sexual contact with Rodriguez, for which there is no proof. Wow. In the present case, both Rodriguez and Long died of strangulation. Rodriguez from the neck compression and Long from ligature strangulation. Both Rodriguez and Long had engaged in consensual sex the day of their deaths. Rodriguez was someone who likely caused his death and flagrant, and Long, according to DNA testing, with 2 other men, and according to Ward, with him at some point. But that's where the supposed similarities, which are no similarities at all, end. The state's analysis would suggest that almost any strangulation that occurred in Houston could be considered part of a common scheme. that is a big stretch and is not possible. But the state has failed to show that these two offenses were committed by the same person, let alone pursuant to the same scheme or course of conduct. As a result, the trial court committed a reversible error. The motion for directed verdict should have been granted. Boy, the state is incorrect that vagueness challenged was not preserved. Here we go. The state incorrectly contends that as applied challenge 2 was not preserved, despite a motion to squash the indictment based on the argument that the statutory provisions is unconstitutionally vague because it fails to define the same scheme or course of conduct. The defendant is alleged to have acted pursuant to, and thus charging instrument failed to provide the defendant notice of what he's charged with, and fails to sufficiently allege the elements of capital murder in violation of the Fifth and Fourth Amendments of the United States Constitution and Article 1, number 10 of the Texas Constitution. An argument about the failure to provide sufficient notice in violation of the federal Constitution is an argument that statutes, as applied, is unconstitutionally vague. This is crazy. In footnote 24, the state acknowledges that federal vagueness challenges to the constitutionality was raised in pretrial writ applications, but the state contends that that was also insufficient to preserve errors, citing Greenwald versus Court of Appeals for 13th Judicial District. Greenwald was a mandamus proceeding initiated by trial court complaining that the Court of Appeals clearly abused its discretion in ordering the trial court to certify the defendant has a right to appeal in a plea bargain case based on a pretrial motion on which the pretrial court never ruled. This issue as mandamus was whether the never ruled upon motion to dismiss had, because of parallel pretrial writ proceedings, somehow preserved the right to appeal, even though the defendant had subsequently accepted a plea deal waiving all rights to any appeal. Greenwald is totally inappropriate. Inapposite. Okay. Likewise, the state's reliance on State versus Ross is unavailing. After analyzing an open carry statute and determined that it was not unconstitutionally vague, this court concluded that an indictment tracking the statutory language was also sufficiently clear to have put the defendant on notice of the charged conduct, noting that charging information need not to be burdened with evidence details. What? Oh my God. If anything, it shows that the issue as applied vagueness challenge was indeed preserved by objecting to the vagueness of the statute as applied to the defendant in the charging instrument. This is, wow. Upon reviewing the arguments and the facts of the law relevant to Poe 1 through 4, this court should reverse and render judgment for Ward. Number 2, reply to arguments related to improper admission of unindicted, unadjudicated extraneous murder in guilt phase. Point of error number 5. The trial court erred by admitting evidence of extraneous, unindicted, unadjudicated murder in the guilt phase under Texas R 404B, absent of factual justification. Number 6. The trial court erred by admitting evidence of extraneous, unindicted, unadjudicated murder in the guilt phase where any probative value of the evidence was substantially outweighed by unfair prejudice. And I'm gonna tell you something, what I see right here, and I think you agree with me, don't you, that there's a lot of unfairness in this trial right here. The things I'm seeing here, I want to know the name of the judge who allowed all this to happen. And when we watch the oral arguments, you're going to learn something about the judge who allowed all this to happen. It's going to shock you. It really is. Anyway, point number 7. The trial court erred by admitting evidence of extraneous, unindicted, unadjudicated murder in the guilt phase, violating Ward's 6th Amendment fair trial rights and 14th Amendment right to due process because of the amount of time he sat before they actually even took him to trial. It's BS. For the reason explained at length in Appellate's opening brief, there was insufficient evidence to find Ward guilty of Rodriguez's murder and no biases for concluding he was responsible for the unindicted extraneous offense, Flood's murder. This was erroneously admitted during the guilt phase, and the decision to permit the latter to help the state prove the former was a harmful error. For Poe 5 through 7 to be rejected, this court would have to sanction the eversation of the rules of 404B and 403, as well as the large body of case law interpreting these rules. The state makes unaliving. This This is crazy. The state makes underlying arguments as to the numerous threshold reasons that flood murder was inadmissible. As a critical threshold matter, the state did not and could not prove Ward committed the flood murder at all, let alone beyond a reasonable doubt. The state cites Fisher versus State, which underscores that a trial court cannot admit extraneous offense evidence unless a jury can find beyond a reasonable doubt the defendant committed the extraneous offense. But Fisher also shows how far the state overreaches in arguing that it provided beyond a reasonable doubt that Ward murdered Flood. In Fisher, the extraneous offense of theft of a rifle was proven beyond a reasonable doubt because the state proved beyond a reasonable doubt that the same rifle, which did not belong to the defendant, was used in the murder that is also proved the defendant had committed beyond a reasonable doubt. By contrast, the state's only evidence linking Ward to Flood is, number one, an unsubstantial claim that Ward, a homeless person in downtown Houston, allegedly admitted to an officer Cisneros that he may have crossed paths with Flood, another homeless person, at some unnamed Houston facility for the homeless at some unidentified time. And number two, last resort, which is YSTR test, results of biological mixture samples from multiple contributors pulled from the unstained portion of Flood's scarf, which also contained DNA from several unknown males. Damn. First, to bolster its non-existent case, the state urges assuming that Ward is guilty of Flood's murder because of an imagined inconsistency between, number one, Ward's video-recorded custodial review, during which he explained at length what had happened between him and Long, and he denied knowing Flood or anything about her murder, and number two, the unsubstantiated claim that Cisneros, that after the interview ended and the recording ceased, Ward said that he may have met Flood at some facility for homeless but denied injuring her in any way. Aside from there being zero corroboration for Cisneros, less than credible testimony on this front, there is no inconsistency or culpability suggested by these statements. And C, by contrast, is Guevara versus the state. Let's see. Finding a appellant who allegedly plotted with his mistress to murder his wife made inconsistent statements by describing his marriage as a good relationship with no problems, admitting his affair and his mistress's motives to kill his wife, and lying about the relevant circumstances and timeline surrounding the murder. How do these fit in with this guy? These don't even fit in. This is wild. Sound. Okay, second, the state distorts the case law on the result of challenging identity. This is C. Lane, Lane versus State. Explaining that raising this issue of identity does not automatically render extraneous offenses admissible. An extraneous offense must be similar to the offenses charged, that the offenses are marked as accused as handiwork. Wow. See also Ford versus State. All right. Finding extraneous offenses of chemical company robbery was erroneously admitted to prove identity of a supermarket robber whose evidence was adduced from the perpetrators of both robberies had worn a purple shirt. Both were tall, both used pistols, and victims were injured in both cases. How does that fit together? Good God, this is so bad, so bad. Third, the state misconstrues the relevance of an argument while conflating, as it did at trial, similarities, it seems, between the Long and the Flood offenses. The germane inquiry is whether there is near certainty that Ward committed the Flood offense so as to justify using it to prove the identity of Rodriguez's assailant. The state use of Ward's confession regarding Long and the mere fact that another homeless woman had been killed, absent evidence of Ward's culpability, to convince a jury to convict Ward of killing transgender Rodriguez in his or her home during a sexual liaison makes mockery of the rule. Amen. Okay, I have to agree with these people. I've got to agree with them. I do. The defense has every right to make the points they're making. The court must hold that the Rule 404B evidence should not have been admitted under such circumstances because there was no inculpatory link between appellant and the extraneous offense. See U.S. versus Gillen. The absence of this link means that in spite of any similarities between the crimes, the jury could not infer culpability for Rodriguez's death based on the extraneous Flood offense. A fortiori, the court should so hold because there are no significant similarities as a matter of law between Rodriguez and the Flood offense. Fourth, the argument that the state needed to inject the Flood murder into the guilt phase to prove Long's murder is completely conspicuous. Ward confessed on video to all facts necessary to establish his culpability for Long's death. Ex parte Thompson versus blah, blah, blah. It's both a common sense inference and an appellate presumption that a person intends to the natural consequences of his acts. But the act of pointing a loaded gun at someone and shooting it toward that person at close range demonstrates an intent to kill. And that's internal citations submitted, blah, blah. Aside from not needing Flood's murder to prove the lack of accident or mistake, this Long's death, all right, the potential for Flood extraneous offenses to impress the jury is an irrational way and was erroneous. And this is crazy. I'm telling you, this is crazy sounding. The extraneous offense in Russell, as with the Flood murder, involved decidedly more heinous conduct than the primary offense. The graphic Flood crime scene and autopsy evidence showing that an elderly woman had sustained extensive inflicted trauma was markedly worse than the evidence establishing that Rodriguez was asphyxiated during a consensual rough sex, an event that, although is undeniably sad, resulted in almost no signs of external injury to the victim. The state seeks an improper pass for extreme misapplication of Rule 404B that would destabilize settled law. Right. The state's unpersuasive efforts to manufacture similarities between the deaths of Rodriguez and Flood must be rejected. The state essentially suggested that because the two very different individuals both died in Houston in a way that involves strangulation, that's just enough. Thus, the state would have this court nullify Rule 404B and overrule, for instance, this court's seminal case, Owens versus State. And concluding to hold that these two alleged sexual assaults were so nearly identical in method as to constitute a system would run the risk of qualifying almost any two crimes of the same class and against the same type of victim as a system. The state's brief makes no mention of Owens. As in Owens, the state below was allowed to put in extraneous offense evidence under a theory of system or modus operandi. And as in Owens, there was inadequate showing that extraneous offenses allegedly committed by the defendant was so nearly identical in method to the charged offense as to earmark them as the handiwork of the accused. Good God. Yet, the state must show more than mere repeated commissions of crimes of the same type of class. The device used must be so unusual and distinctive as to be like a signature. Okay. If there was no sufficiency distinctive characteristics, then the relevancy of the evidence cannot outweigh its prejudicial value. The internal citation, okay, so they're not talking about that citation. In Owens, this court noted that the primary and extraneous offenses were certainly alike in that they were both sexual assaults committed against minor females of approximately the same age at the time of the alleged offenses, both of whom were appellate's daughter. Okay, wait a minute. Oh, that's in the Owens case. That's a whole separate case. Maybe we should look at the Owens case next because he's something to his own daughters. That sounds interesting, but those similarities, which is an objective comparison of the Rodriguez and Flood offenses, do not yield and was deemed insufficient to permit admission under Rule 404B because those offenses were not so compellingly similar that an objective trier of fact could, upon examining only the similarities of the two offenses, conclude with any certitude that they were so alike as to identify both crimes as the work of the same person. The Rodriguez and Flood offenses do not come close to satisfying compelling similarity. I agree, they just don't. For the test to prevail, this court would have to disavow an extensive body of case law finding reversible error, which is relied on to teach Rule 404B to practitioners and law students. Caldwell versus State, holding admissions of testimonies in rape cases that the defendant had attempted to rape the prosecutrix's sister less. Wow, this is a weird one. Holding admission of testimony in a rape case that the defendant had attempted to rape the prosecutrix's sister less than a month earlier was an error, noting that to find the admission permissible would be tantamount to holding that such testimony would be admissible in any case where a defendant's counsel exercises the constitutional right of cross-examination that is not and should not be the law. Okay. Ford, this is another one. Explain there will always be similarities in the commissions of the same types of crime. that is, in any case of robbery by firearms, is quite likely to have been committed in much the same way as any other. What must be shown to make the evidence extraneous of a crime admissible is something that sets it apart from its class type of crime in general and marks it distinctly in the same manner as the principal crime. Mercy is Murphy versus State. Finding admission of extraneous offenses was erroneous in explaining at length how such error can be inherently prejudicial and conduct that offends our system of justice. Yes, this is very offensive, I will say this. Colazo versus State. Explaining when identity has become contested material issue, as it did in this case, there must be a showing that extraneous offenses which was committed by the defendant was so nearly identical in method to instant offense as to earmark them as the handiwork of the accused. Much more is demanded than the mere repeated commission of a crime of the same class, because almost any two sexual assaults could be characterized as sadistic acts, just as almost any two murders could be characterized as a violent act. This is nothing more than dressing a psychological garb that the very thing that the law on evidence of extraneous offenses forbids, proof of the repeated commission of a class of offenses to demonstrate that the defendant is a criminal. Thompson versus State. There's a whole bunch of these. Okay, so I'm going to skip past some of these because they're just talking about in cases where, clearly one case could look like another, but that doesn't mean the same person did it. So we're going to move past some of those. Okay, when the state was permitted to do, okay, here we go. When the state was permitted to do a trial was a radical departure from a deeply entrenched understanding of basic rule of evidence. This court said its best in Newman versus State. Since 1918, Texas courts have consistently held that before extraneous offenses may be properly admitted into evidence, there must be some common distinguishable characteristics, a series of distinguishing characteristics between the offense charged and the extraneous offense. In the absence of such a rule, remote and completely unrelated offenses might be recited to the court in order to show that the defendant is simply a bad character or a criminal generally. Obviously, such prejudicial tactics must not be permitted. I agree. Now, we're going to go back to Rule 403 was plainly violated. Yes, I believe it was. Since the unindicted flood murder was inadmissible under Rule 404B, admitting it most certainly violated Rule 403. The convoluted limiting instructions used below could not limit the egregious harm associated with allowing the state to inject the unfairly prejudicial flood murder into the guilt phase. As the court has aptly explained, relevant criteria for 403B analysis, including considering whether the misconduct was of such a nature that a jury instruction to disregard it for any but its proffered purposes would not likely have been effectuous. Wow. Montgomery versus State. Ooh, it's hard to read all this. When the record reveals one or more such relevant criteria reasonably conducting to a risk, the probative value of the tendered evidence is substantially outweighed by unfair prejudice, then the appellate court should conclude that the trial court acted irrationally and failing to exclude it and thus abused its discretion. Yes, I agree. The obvious harm was extreme considering the outsized role that flood murder played in propping up the state's weak guilt phase case for capital murder. The state's theory was that Rodriguez and Long had been murdered pursuant to same scheme or course of conduct, despite significant differences between the two crimes and the victims. It relied on Flood's murder, an unadjudicated offense, to obscure the significant problems with its capital theory. The state's closing arguments focused extensively on Flood's murder, which should have never happened. Moreover, the jury instructions show that Flood's murder was used to try to buttress a finding of guilt for primary offenses. He had already admitted to killing this other lady. They didn't need to do all that, but they wanted to make him a serial murderer, so they threw that in there. That's what's happened here. Reversal is required for the distinctly harmful error caused by allowing the state to present a full day of evidence regarding the deeply disturbing flood crime. The admission violated Rule 404B, Rule 403, and the fundamental federal rights to a fair trial and due process of law. Finding that the 10th Circuit erred by not considering whether the prejudicial impact of evidence introduced at trial violated the federal rights to a fair trial and due process when considering whether to grant habeas relief from a conviction and death sentence, relying on, and there's another case that they're going to talk about, when evidence is introduced that is so unduly prejudicial, it renders the trial fundamentally unfair. The due process clause of the 14th Amendment provides a mechanism for relief. Reply to arguments related to bias tribunal. Okay. Point of error 8. The trial court erred by denying the defense's ex parte motion to disqualify all members of the district attorney's office who have been exposed to the privileged information in former defense counsel's motion to withdraw, thereby depriving Ward of a fair trial. The state endeavors to recharacterize this point of error as an ineffective assistance of counsel claim. The state attempts to brush aside this error by arguing that Ward did not adequately brief an ineffective assistance of counsel claim. He didn't write his own brief. Oh boy. The error, however, is that the trial courts, based on Ward's attorney disqualifying conflict of interest. Damn. To prove the existence of conflict of interest, a defendant must allege more than the counsel should have engaged in different behavior to protect an interest. Okay? In Sandoval, this court concluded that an attorney's interest in protecting against the subsequent accusations of ineffectiveness did not constitute a conflict of interest, just because of inartful attempts to protect the non-conflicting interest. Indeed, this court found no conflict of interest in Sandoval, emphasizing that the defendant's desire for control over strategic decisions has prompted an ex parte hearing held for his benefit. These facts do not resemble the actions of Ward's lead counsel, Gazier, who was very public. Self-interested conduct was adverse to the client and beneficial to his client's adversaries. Filing an inflammatory motion to withdraw without informing his client, claiming the jail refusing to manage Ward's dangerousness, and divulging damaging confidential information purportedly from a retained consulting psychiatrist, Mark Moeller. Oh boy, this is getting good. Unlike defense counsels in Sandoval, who allowed the defendant an unusual degree of control over their strategy, Ward's concerns were ignored. He filed a pro se motion to seek substitute counsel and represent himself due to Gazier's failure to communicate or work with him on his case. Those motions were ignored for over a year. Also, Ward made clear that it was not a matter of seeking control. He wanted representation but preferred to represent himself if the alternative was a lawyer uninterested in defending his client. I don't blame him, not one bit. Similarly distinguishable in Monreal versus State, in which the court found no conflict of interest and where an attorney merely put into the record in jury's presence that she had informed the defendant of a plea bargain offer which he had rejected. Oh my God. Gazier placed the detrimental confidential information into a public filing to enable him to withdraw and avoid his client's allegations of neglect in a death penalty case, an action that was wholly unwarranted and did nothing to benefit the client. I'm telling you, Sprinkle, this is bad. This is really bad. When you listen to all the things that's taken place in this, oh my God. If Gazier's summary of the counseling psychiatrist's opinions are to be believed, that Ward needed injectable, long-acting antipsychotics to control his behavior, those opinions plainly cast doubt on Ward's competency to stand trial. And yet the state asserts that Gazier's motion to withdraw did not suggest a possibility that Ward may have been incompetent to stand trial. This is demonstrably wrong. Gazier's motion plainly states that Dr. Moeller had expressed doubt as to the defendant's competency to stand trial. But Gazier obtained county funds to retain a consulting expert ostensibly for his client, then used the expert only against the client to further the lawyer's own interest in getting off the case. In other words, the lawyer sees he's not going to get paid. He's going to lose this case. He doesn't want it on his record. So he goes out and finds a way to get off the case where he doesn't look bad. But he looks bad in my eyes. This was pathetic. And pursuant of his self-interest, Gazier prejudiced the trial court against Ward and assisted the state by suggesting that a client he knew to be mentally ill was hopelessly dangerous and thus deserving of the death penalty. Oh my God. This is so unfair. Summarily denying the motion to disqualify DA's office was reversible error because it deprived Ward of his right to remedy for the constitutional harm his conflicted counsel caused. The state begrudgingly acknowledges that Gazier's motion contained privileged and confidential information. The fact that some information in Gazier's motion was not privileged does not transform the motion into something benign. In Weatherford versus Bursey, establishing that the Sixth Amendment right to effective counsel, assistance of counsel, protects a defendant's privileged communications with counsel and attorney in their work product from government intrusions. The harm was palpable, aiming that the states with a dossier of damaging and confidential information that plainly biased the tribunal against Ward. I agree, it sure did. It sure did. The state cites Williams versus State for the proposition that a trial court may not disqualify district attorneys based on a violation of the disciplinary rules alone or without showing a prejudice. Here, Ward does not rely on the prosecutor's violation of disciplinary rules and does show prejudice. Thus, these cases are inopposite. In Williams, the defendant filed a motion to disqualify the Hunt County DA's office based on allegations that law enforcement personally violated the trial court's ex parte orders requiring the defendant's visits with the expert witnesses remain confidential and that the identity of the visitors and the purposes of the visits not be disclosed. They absolutely should be confidential. Absolutely. The DA's office gained access to the visitor's log because a deputy put the confidential visitors into the system under a faulty assumption that only the jail could access this information. The state learned only the names of the visiting experts, not anything about what the experts did while visiting the defendant or what the opinions of the experts may have found. It's still a violation. The state contends it did not use the information in Gazer's motion to obtain otherwise unknown, unavailable evidence, but that it was a straw man argument. The DA's office did not need to use Gazer's motions to obtain otherwise unavailable information. Gazer had disclosed confidential information, opinions of the defense consulting expert, via the public docket. Damn. Likewise, the state's reliance on Landers is unavailing. The DA and Landers used only publicly known information developed in a previous criminal case. Here, the DA's office obtained the opinions of a defense consulting expert, which are inherently confidential and that were being formed in the very case being prosecuted. Point of error number 9. The trial court erred by denying Ward an unbiased tribunal in violation of his Sixth Amendment fair trial rights and 14th Amendment right due to process. The state implicitly, I can't speak now. The state concedes that the right to be tried before an unbiased tribunal need not be preserved with a defense objection. The state otherwise misses the mark. Ward's fair trial and due process rights were eviscerated by a series of actions, by a series of presiding judges during the state's decade-long quest for evidence to support its allegations that had found a serial killer. Collectively, these presiding judges failed to ensure that the defendant was not saddled with conflicted appointed counsel, that the defendant's competency was properly assessed, and that he was not tried while incompetent, that the defendant was present during all mandatory and essential phases of the pretrial and the trial so to participate in his own defense, and the defendant was prosecuted by individuals with a commitment to justice, not just winning at all cost. In defense of this unprecedented mess, because it is a mess, I agree with him, the state relies on cases that are not merely distinguishable, but actually highlight just how extreme the due process deprivation was here. For instance, Sandoval, the appellant, alleged that he was denied his right to a fair and impartial tribunal because his attorney shared some confidential information with the court during ex parte conferences, not with the world, as occurred with Gazer's inflammatory motions. This court found no evidence of bias with respect to the ex parte conference in Sandoval, and such conferences are inevitable when the trial court is charged with appointing a defense counsel for indigent defendants and adjudicating defense's request for investigative resources. This court found that the trial judge's conduct in Sandoval seemed intended to benefit the defendant because during these conferences, the defendant was provided with reasons for his attorney's actions and was asked whether he was satisfied with representation he was receiving. However, none of the evidence of the bias to which Ward points to could be fairly construed as acts undertaken for his benefit. Indeed, Gazer represented that representations that a retained psychiatrist had found Ward incompetent and in need of injectable antipsychotics medications was not even discussed, let alone acted upon. Instead, Gazer's motion became the distorted prism through which Ward was prejudiced years after it was filed. Gazer's outrageous motion shaped judges' presumptions that Ward was so dangerous he should be excluded from virtually all pretrial proceedings. That is incorrect. That is not fair. Moreover, quite unlike the Sandoval conference, the proceedings to which Ward points to took place in open court, but without Ward's knowledge, and included state's counsel who were even invited to weigh in about the matters that they had no standing to advance, such as who represents Ward, a hearing during which a plan was hatched to conduct a sham Faretta hearing and prototypical when Ward's request to represent himself was not simply prejudiced, but treated with disdain. An objective jurist should have considered that Ward's pro se motion seeking substitutive counsel, ignored for a year, might have been based on legitimate concerns about his appointed counsel's complete failure to communicate with him. An objective jurist should have been appalled by both the content of Gazer's motion to withdraw and the fact that it was not filed ex parte under a seal. An objective jurist should not have been complicit in keeping Ward in the dark about his own counsel's very public portrayal. Instead, the harm caused by this collective abdication was allowed to fester. Sandoval does not involve analogous facts. Okay. The state also relies on Letke versus U.S., which considers the tangibility relevant issue of when recusal is required under federal law because a judge's impartiality might reasonably be questioned. Letke involves an attempt to recuse a judge based on events that had occurred during and immediately after an earlier trial involving the same defendant before the same judge. The Supreme Court found inadequate evidence to suggest an appearance of bias because the judge's conduct consisted only of judicial rulings, routine trial administrations, and efforts of and/or ordinary, if sharp, admonishments to counsel and to witnesses. Unlike the present case, there was no evidence that the judge in Litke had been influenced by information extraneous to normal proceedings over which he had presided, or that he displayed deep-seated antagonism that would render fair judgment impossible. By contrast, Judge Velasquez decided that Ward, here's the name of the judge, Velasquez decided that Ward was irredeemably dangerous, not based on her own experiences, but based on Gazer's flagrantly improper motion to withdraw, filed years before she assumed responsibility for this case. Oh my God, this is horrible. Judge Velasquez knew, or she should have known, of considerable press attention being paid to the case and that the journalists could access the docket. But instead of protecting the forum integrity, she repeatedly referred to Ward's as dangerousness in open court. Yet during the sole proceedings before the Judge Velasquez, where Ward was brought to the court, the record shows he did not even speak. When Judge Silverman took over, he presided in a manner that reflected antagonism toward a defendant with whom he had no history and whose rights were flagrantly violated throughout the trial over which he presided. Like a preconceived notion that German Americans have hearts reeking with disloyalty, and an espionage case against German American defendants, a preconceived notion of the defendant's dangerousness in a case in which the defendant's future dangerousness would be dispositive sentencing issue reflects intolerable biases. Sorry guys, it's hard to read all this. Finally, the state invokes Gale versus State, which is also inapposite. Gale involved the denial of a recusal motion. The recusal request had focused on the trial judge's comments that only plea bargains he would accept would be for a maximum sentence. This court found that because the remark referred only to a plea bargain and not for a sentence he would impose following the trial on the merits, the presiding judge had not abused his discretion in denying the recusal. Here, a trial judge did not simply make one indigenous comment. Ward was described as very dangerous in open court based on an inadequate and accurate knowledge of his history with counsel, seemingly to justify deciding numerous substantive matters outside his presence, such as how to handle the state's disclosure that he had long misrepresented the status of their DNA testing, revelations about lost and mishandled evidence, and speculation about whether mental health assessments that Ward had been or should have been conducted by and whom. Boy. In short, the state's case reflects the far cry from the conduct relied on here to urge reversal for a new trial before an unbiased tribunal. And reply to arguments related to Chapter 46B and incompetency to stand trial. Incompetency is a real big factor in this, and when you watch the oral arguments, you'll understand that. Poe 10-22 all arise from the procedural inadequacy of the trial court's assessment of Ward's competency to stand trial. The court has made it clear its experts trial courts to follow the non-discretionary directives that Texas legislature took pains to craft to ensure that defendants are not tried while they are mentally incompetent. So he says, explaining that if a scintilla of evidence exists to support a finding of incompetency, then the statutory scheme requires the trial court to conduct a formal competency trial. Okay. Unanimous unpublished decisions describing Chapter 46B's requirements and holding trial court error in failure to follow them. Because Chapter 46B was egregiously violated, the process fell far short of the due process, requiring reversals. The state endeavoring to excuse the consummate failure to comply with the governing statute and the state's interpretations thereof relies extensively on Moore v. State. Moore was decided several years before Chapter 46B was enacted. The lay misassumptions about mental illness evident in Moore may have been part of the impetus that led to enacting Chapter 46B, so that the courts would have much needed guidance about how to perform constitutionally compliant competency assessments. Allison Myers, mentally ill and mentally retarded defendants in Texas may get a chance at justice. Recommendations at the task force. Okay, this is something else that you can read that talks about how this came about. Okay, explain that the governor's creation of task force in response to concerns about inconsistent reporting and standards, inadequate use of sufficiently qualified mental health experts in a criminal case, and citing Moore as an example of a case in which the holding was inconsistent with ABA standards and other jurisdictions of due process jurisprudence. See also Terry Maroney, emotional competence. Okay, these are things that you would read, but we're not going to read all that. So it says, citing Moore as an example of decision reflecting highly confused attitude as to the relevance of mood disorders and the competency inquired, and explaining how and why competence to stand trial is highly under-theorized area of law, even though competence is an important issue in many criminal prosecutions. The state cites Moore so often that it's listed as PASM in its index of authorities. Yet Moore, which is pre-Chapter 46B, pronouncements about the procedure for assessing competency are wholly inopposite. It should not even be applied. Additionally, the state relies on unavailing error preservation arguments, citing, for instance, the fact that the defense counsel did not object to the appointment of a conflicted expert or expose the inadequacy of the expert's evaluation through cross-examination. SB 184. But cases such as Blunson illustrates a trial court's failure to comply with mandatory provisions is not excused by the defendant's counsel's complicity. Boy. Points of error 10 through 12. The trial court violated Article 46B.004 by repeatedly failing to respond to suggestions of Ward's incompetency, and when and after implicitly acknowledging suggestions of incompetency, the court failed to pursue an informal inquiry or stay all other proceedings in the case. And the trial court violated Article 46B.004D when, after finally ordering a competency evaluation, it did not stay all proceedings in the case to permit the adequate assessment. Once the court receives some evidence from any source that the defendant might be incompetent to stand trial, all other proceedings other than the informal inquiry must be stayed. Below, there was far more than some evidence of incompetency. Even the state acknowledges that the psychiatrist initially retained by defense counsel and later court appointed to do a sham competency evaluation apparently believed that Ward needed injectable, long-acting antipsychotics to control his behavior. SB 145, emphasis added, it would be a pronounced breach of medical ethics for a doctor to recommend injectable antipsychotics to someone who is not in fact struggling with florid mental illness and thus having trouble conforming his behavior with social norms. But instead of heeding that numerous suggestions of incompetency, the mental health problem was just disregarded for years. This is so bad. It is so bad. At this point, the state argues that Ward himself should be treated as the authority on his mental competence in 2020 because in 2014 he felt he could better represent himself than in appointing counsel. SB 145, quoting Ward's statement, I do not think my epileptic would interfere with representing myself, and I do not think my mental deficiencies would interfere with defending myself in any way. Well, see, that should tell you right there that something is not quite right. Because what's the old saying they always say? Somebody trying to represent themselves as a fool. Anyway, Ward's self-assessment is especially irrational under the circumstances, not evidence that he was competent 6 years later. This has went on and on for a long time. During the voir dire in January of 2020, a superficial, non-compliant informal inquiry was launched by a visiting judge who had no history with Ward or the case. There was no stay, and virtually all mandatory procedures were disregarded. Ensuring competency is not a process that can properly be conducted on the fly over a weekend in the middle of voir dire simply to check some box or move on, even as the defendant's mental decomposition was on full display. Ward in court, his conduct and other record-based evidence cast considerable doubt on Ward's ability to cooperate with counsel and to rationally as well as factually understand the proceedings. While pointedly soft-pedaling the facts, even the state forced to admit that by trial, Ward was expressing paranoid delusions about conspiracies between the presiding judge, the prosecutors, the potential jurors, and the jail personnel, the bloggers on the internet, and the defense counsel who attested on the record that Ward's paranoia and inability to listen to us speak to us when he was asked a rational way on any decisions about his trial, making it impossible to meaningfully engage. This is bad. But the evidence of incompetency, including a suicide attempt in the holdover cell, is simply dismissed as misbehavior. A suicide attempt per se is not dispositive of incompetency, but it is certainly relevant. And Drope, a seminal competency case, the U.S. Supreme Court reversed in part because the trial judge had disregarded the defendant's mid-trial suicide attempt as just difficulty brought about by the defendant. Drope versus Missouri. In reversing for a new trial, the Supreme Court emphasized that the suicide attempt was one factor suggesting incompetency, while noting that the record as a whole revealed a failure to give proper weight to the information suggesting incompetence which came to light during the trial. Similarly, the trial court here did not give any weight to the suicide attempt, even though it occurred soon after. Ward had given a long, rambling monologue about how his lead counsel, Isabel, had in Ward's mind previously caused his death by announcing in court one day that the woman Ward thought was his mother was not his mother but his sister, and the woman he thought was his grandmother was actually his mother. Ward persevered before a baffled Judge Bradley. Oh boy. Miss, this is what he said. Miss, I committed suicide January the 24th of 2016. I overdosed on a bunch of pills. Committed suicide. It took me to the Bentov Hospital. I OD'd. I died. They brought me back to life with shock treatment. I died at 10:30 or something at night. They brought me back to life finally at 1 o'clock in the morning. Both of my lungs collapsed. I couldn't breathe. They intubated me all because of what Mr. Isbell said about my family with nothing. And why, he said. He said, I don't know. Boy, that is so bad. Before Judge Bradley could respond, Ward continued raving about how Isabel had called him a nightmare in the newspaper and preferred a different client facing capital charges who was white. The race card. Bad. And this was just the tip of the iceberg in terms of the unhinged rants from a man who had, for decades, been diagnosed with serious mental illnesses, including clinical paranoia, fixed delusion, and schizoaffective disorder. It would be comical, if not so gravely serious, if the state repeatedly insisted that none of the evidence before the court amounted to some evidence that his purported inability to rationally engage with counsel was caused by mental illness. SB 194-95. Chapter 46B was enacted to prevent this kind of ostrich approach by largely removing the competency inquiry from the adversarial process and allowing the truth to be ascertained with the help of qualified professionals. But when this case was finally careening toward trial, the presiding judge and counsel failed to heed Chapter 46B's clear statutory mandates. Once there is a scintilla of evidence supporting the suggestion of incompetency, which there plainly was, the statutory process cannot be circumvented without undermining the entire inquiry. By deciding to appoint an expert, Dr. Mark Moeller, to do a competency evaluation, the court was then required to stay all proceedings following the statute and proceed to a full-blown formal competency trial. This did not occur. So, what page are we on? Oh boy, I didn't realize it was 100. Okay, listen, there's 120 pages to this. I don't know if we can read all 120 pages. Let's do this. I'm going to go down to the bottom, and there's this little section right here. Hang on. Well, we'll read. Okay, the trial court violated Article 46B by appointing expert witnesses not disinterested and did a hasty, inadequate assessment, and the trial court violated Article 46B by failing to ensure the appointed expert was provided information relevant to determination of the defendant's competency. And the trial court violated Article 46B by failing to obtain a written expert report by only an oral report, did not address the statutorily mandated considerations, and the trial court violated Article 46B.022 by failing to ensure the court-appointed expert was appropriately qualified. He did not even meet. Okay, so he did not even meet with Mr. Ward. He never met with him. He did not observe anything. I don't know where he got his information. There's a spot down here. Let's see. Let's summarize this so we can go watch. I want to watch the oral arguments. Hang on a second. It's going to summarize it for us. Make it a little easier. Okay. For larger than 100 pages with complex tables and figures, blah, blah, blah. Okay. Here we go. This document is replied to. Here's the legal. We're going to read it like this. We're going to go back over to the highlights so we can go on to the oral arguments because that's the best part of this case. The appellant highlights multiple errors, including the state's delayed filing, factual distortions, and improper evidence and omissions, critical issues involving insufficient evidence for guilt, improper handling of competency, and rushed trial proceedings despite delays in DNA. Listen, there's nothing rushed about this trial because this took 10 years. 10 years. There's no reason for a trial to take 10 years. Just understand that. Evidence of misrepresentation and DNA evidences. The state falsely claimed that Ward's pubic hair was found. The state exaggerated the significance of DNA evidence linking Ward to Rodriguez. Same scheme in court. We've talked about the same scheme. The unpreserved vagueness is challenged. The appellant's motion to squash based on the unconstitutionality was properly preserved through a pretrial motion. The state's reliance on inapplicable cause law to claim error was not preserved and is rejected, and the challenge was adequately raised. Admissions of extraneous murder evidence. We've talked about that. Insufficient evidence. We've talked about that. Let's go down to where we left off. Violations of Rule 403B. We've talked about that. The misapplication. We've talked about that. Reversal due to fundamental evidence errors. Improper evidence introduction of Rule 403B violation constitutes reversible error, undermining the fairness of the trial. This use of highly prejudicial, unadjudicated extraneous offenses violates its core principles of a fair trial. Conflicts of interest, we've talked about that. Denial of a fair trial, we've talked about. Let's see, failure to respond. Let's get down here to the bottom where we need to. Trial court's ongoing incompetency, we've talked about that. Okay. Right to be preserved. Ward was inappropriately excluded from. We've talked about that. Hang on a minute. Jury selection. Let's get down to jury selection. The trial court erred by excusing jurors when Ward was not present, violating Article 33.03, especially as Ward was heavily medicated and unable to assist counsel. Such absences harmed Ward's case, particularly during the punishment phase, and created negative inferences about his presence and participation. Cumulative trial and procedural errors. Multiple errors, including exclusion from proceedings, improper jury excusal, and denial of continuances, collectively tainted the trial's fairness. The errors, especially regarding Ward's absence and competency, require reversal and remand for a new trial due to the fundamental constitutional violations, the prosecutorial misconduct, and improper comments. The prosecution made prejudicial comments, including calling Ward a serial killer, which inflamed the jury and violated due process. The state's closing arguments relied on improper appeals, misrepresentations of evidence, and inflammatory language contributing to fundamentally unfair trials. False testimony and evidence suppression. Detective Cisneros provided false and misleading testimony about the case pattern and evidence, which was instrumental to the state's theory. The state ignorantly and negligently sponsored false testimony and suppressed evidence violating Ward's Sixth Amendment rights and due process. Exclusion of defense evidence. The court arbitrarily excluded a record of similar local strangulation cases, hindering Ward's right to present a complete defense. The exclusion was based on hearsay and relevance arguments that were improperly applied, impacting the fairness of the trial. Vagueness of future dangerousness. We kind of talked about that already. The right to fair trial and due process. Ward's absence during the trial and the court's failure to assess his competency led to violations of the 6th and 14th Amendments. The extensive absence of Ward from the trial proceedings caused harm, especially during the guilt punishment. Batson discrimination by jury strikes. Okay. The state's use of peremptory strikes against 5 qualified black female jurors violated equal protection rights. The strikes were based on discriminatory reasoning, and the defense Batson's objection was properly preserved and supported by evidence of disparate questioning. Denial of continuance for expert review. The trial court improperly denied continuance needed for the defense to evaluate the state's novel STR mix and DNA technology. Denial prevented Ward from obtaining expert assistance, violating his Sixth Amendment rights, and requiring a new trial remand. The prosecutorial overreach and improper argument. The state's closing arguments included inflammatory and unsupported claims, such as labeling Ward as a serial killer, which prejudiced the jury. The cumulative improper comments and appeals to emotion created a fundamentally unfair trial, warranting a reversal. False testimony and evidence suppression. Detective Cisneros provided false and misleading testimony about the case and evidence, which was central to the state's theory. The state sponsored false testimony and suppressed relevant evidence, violating Ward's constitutional rights and undermining the trial integrity. The vagueness challenge. We've talked about the vagueness already. The Supreme Court's approach to vagueness. Recent decisions reject the idea that laws are constitutional if some conduct clearly falls within their scope. Courts now focus on whether the statutes are vague in all applications, emphasizing the importance of a case-specific analysis. Comparison with ACCA statutes. Johnson, DeMea, and Davis cases were found statutes unconstitutionally vague to rely on the judge's guesswork about conduct. The statute's requirement for judges to predict future conduct creates unpredictability, similar to the future dangerousness of special issues. Okay, we're almost to the bottom here, guys. Future dangerousness and special issues. These issues ask jurors to speculate about future bonds without clear guidance, leading to constitutional concerns. Its reliance on lay jurors' predictions about undefined future acts makes it vulnerable to being void and vagueness. Okay, so, oh boy, now let's go find the. We're gonna go over here. We're gonna get off of this for a second. Hang on, guys. Oh boy, it's a lot to read. It's hard to read. There's a lot to it. But what we're gonna do now is we're gonna go watch the oral arguments. So this case, we're talking about 10 years in the making. All right. Oh, I need to do this. Okay. It took 10 years in the making. They came up with all kinds of garbage evidence. Simply, I'm going to say this, and you know, let me see. Unsolved. I can't read your name there. It's kind of too small. Unsolved. Thanks for coming in. We appreciate seeing you. Thank you, Cinderella. I know it's a lot to read. I know it is. But let's go find the oral arguments right quick. And we'll watch that. Let's see, oral arguments. Hang on. This case has a lot to, I feel like the guy was railroaded, and if he was, I'm going to say it, and I'm not prejudiced at all, you'll know that. If he was white and he would have had a high-paying attorney, none of this would have happened to him. None of it. Anyway, oral arguments, let's watch those. Here we go. Whoops. Lucky Ward. This is very interesting when it gets to the oral arguments. You're going to enjoy this. Read more. Okay, let's go. Come on. Here we go. All right. I have to pull this up on YouTube, so just bear with me for a second here. Is this it? Yes, this is it. So let me change my screen up. Here we go. Let's share the screen and get our oral arguments pulled up. Share the screen. Okay, here we go. All right, here we go. And this is going to be full credit to Texas Court of Criminal Appeals. And here we go. I'm going to make it bigger. All right. Is it going? Yeah, good. All right, now. All right. They're not here yet. Let me put my fair credit and all that, my fair use. Here we go. Here, whoops. Texas Court of Criminal Appeals. God, why is this so little today? All right. Okay, let me put this over here. Thanks, guys. Thanks for your patience. Full credit. All right, here we go. Oh. All right, here we go. All right, here we go. Now, and as soon as the sound starts, I'll go ahead and let me speed it up so we can go ahead and watch this because it's very interesting. I really enjoyed watching this one. Here we go.
If you'd be so kind.
Okay, here we go. And this is the Lucky Ward case.
You may proceed.
Lot to read, lot to read.
Mr. Presiding Judge, may it please the court. My name is Gretchen Swen, and I represent appellant Lucky Ward. Mr. Ward was convicted and sentenced to death in Harris County in March of 2020. This was nearly 10 years after his arrest, at which time he confessed as a mentally ill homeless individual to having caused the death of his friend, another homeless individual, Rita Long. That confession was captured on videotape in the police station, but reliable murder on Texas Penal Code 1903A7B, which requires proof of two different murders in two different transactions involving the same scheme or course of conduct, which this court has had some recent
The
familiarity.
statute is a little broader than that, doesn't it? I mean, it allows conviction upon demonstration of multiple murders, right? Not just two.
Correct, Your Honor. It can be more than, it's more than one is the burden of the state, but there must be, when they're not part of the same criminal transaction, they have to prove this same scheme or course of conduct. And it is our position that they did not even articulate a legally cognizable common scheme, nor did they adduce legally sufficient evidence of the second murder that was the charged offense, the murder of Carlos Rodriguez, a transgender individual who was found dead in his home following or during a sexual interaction. So there were two murders, one to which Mr. Ward had confessed and which provided the state all the information they needed to obtain a conviction, and then one he vehemently denied having any role in, although he also volunteered to the police that why his picture was on the camera of Rodriguez, which was found in
Counsel,
Rodriguez's.
what is the issue? What are you arguing here?
Mhm.
I mean, how many issues are there in this
A lot.
case, and what are you arguing?
This is an excellent question, Your Honor, and I appreciate the chance to pivot. Part of the problem here is this case is so larded up with error. It was very difficult to designate issues that I would like to discuss in the limited time I have, but that is irresponsible. So I will quickly say, I'd like to start with points of error 10 through 22, which involve Mr. Ward's competency to be tried. Even though it took 10 years for the state to come up with evidence and
That's kind of why I asked. I'm like,
Yes.
you're telling me all this
Yes.
stuff about different
Right.
reducing things, but it seems like
No. I'm going to stop it for just a second before you talk for just a minute. Have you ever heard 10 years to come up with evidence to try a person? No, this is so wrong. So wrong.
But there's this paradox here that I'm suggesting there was a rush to trial when Mr. Ward was showing overwhelming signs of incompetence. But part of this delay was this effort to find evidence to support a theory, as opposed to evidence leading to a theory. So Mr. Ward showed overwhelming signs really throughout this 10-year period that he was a person with serious mental illness. Well documented. He was a guy that MHMR had designated as disabled because of his mental health issues. He had a monthly disability check. Lots of evidence of mental illness, yet he was never properly assessed for competency. He was excluded from most substantive pretrial hearings because of comments made about how he wasn't capable of being there. And he was excluded from a chunk of voir dire, which is against statutory law. And he was excluded from much of his trial, not because of a voluntary waiver, but because he was showing these flagrant signs he was incompetent. And there was a reluctance on the part of the court to pause and figure out what was going on. And as Your Honor is very aware, we have this wonderful statute, Chapter 46B, that the legislature took great pains to craft after years of recognizing there's a real problem in the criminal justice system of mentally ill people being tried while incompetent, and that judges and lawyers aren't necessarily trained to recognize the complexity of mental health issues that interfere with their ability to rationally engage with counsel and to comport with social norms that are expected in the courtroom. So we have this great statute, and I've provided Exhibit 1 to the oral argument, which includes a flow chart that appears in bench books provided to judges to help them, because this law was seen as so innovative, but it's, again, not intuitive. It's mandatory that once you see suggestions of competency, You stay whatever the proceedings are and then follow the flow chart. Here, as outlined in points of error 10 through 22, virtually nothing about the statute was honored. We have Mr. Ward coming unhinged during voir dire.
I just wanna
Yes.
slow you down a little bit. You mentioned this flow chart was an exhibit. And so to some degree, is that in the statute itself, the flow chart? Or is that something that someone else created in order to help other people to understand how the statute should
Let me
work?
check that.
Judge Yuri, it's the latter.
Okay.
And as we noted in a filing, there was an objection to the exhibits, that this is not part of the statute. It is a demonstrative exhibit of the statute that is prepared for a bench book.
Do we know like who prepared that, or is that?
This one is from the 2019 version of the Texas bench book on mental illness. And in my filing, I said it's,
Is that right? Prepared for trial court judges? to follow?
yes, Your Honor. And I believe that the Honorable General Counsel, I'm sorry, I'm sorry.
The bench book is drafted by whom? It's not subject to bicameralism and presentment. It is not approved by the House, the Senate, and signed off by the governor, correct?
That is correct, Your Honor. But for instance, a member of the General Counsel of this court was on the committee that prepared the bench book, the most recent version published in
And I'm
2021,
sure
which has
it's-
the
I'm
identity.
sure it's very well written, but the question that's coming to you from someone is going to be, would departing from it violate the law?
And Your Honor, I would say yes, because the statute is replete with mandatory language, shall, must. And as this court, in a unanimous decision in another death penalty case of Damon Blunson, made clear, once there is some evidence, and that is a low bar, one must stay the proceedings and follow the statutory guidelines, which include, once there is some evidence, and one is only allowed to consider evidence of incompetency, not competency, then there must be appropriately appointed experts to do an exam per the statutory guidelines. You have to have 30 days minimum to review collateral sources, do the assessment, provide a report. None of this stuff happened. You had,
Competency, hearing before the trial started.
Your Honor, there was, in the middle of voir dire, when the client,
Not before the trial, was there any type of competency hearing requested before the trial started?
no, what is bizarre is in the record, there are a couple of, in the clerk's record, a couple of these forms suggesting that a magistrate requested a mental health evaluation, but there's no record it ever happened, no report as mandated by law. What we have over the years are lots of comments on the record about Lucky Ward's mental health, about, for instance, him thinking he's being poisoned and losing a lot of weight. He himself, the few times he was allowed to come to court, talks about.
At what point was there ever a competency hearing?
It's our position, there never was. There was no competency. There was a hearing.
Was there a hearing where a judge presided over a hearing and made a finding that he was competent or incompetent?
What happened, Your Honor, is that during voir dire, there was a meltdown and counsel asked the judge, begged the judge to stop. Their client attempted suicide in the holdover cell. Things had gone crazy. They said they could not rationally communicate with him. And the judge, and this is important to recognize, had been brought in to cover voir dire. She had not been a part of this case for the 9 years before. She says on the record, it's not uncommon, and especially here where you had a judge who had been elected and had no known criminal law experience. And so she was going to, this experienced judge, come in to cover voir dire. She makes comments about prior competency evaluations. And the defense says, we're not aware of any. Because in fact, there weren't. There was never a time. There were suggestions of incompetency made in documents, in court records, but no evaluation. When she finally is told, you're about to inject error into this case under Turner, if you don't pause, she stops voir dire, but Lucky Ward is not there, then continues to interview jurors outside his presence, but then appoints, this is Friday,
Like
a judge, a psychiatrist.
She continued jury selection
Yes,
with the defendant removed.
yes, she did. After he'd been removed, she continues to hear excuses. She doesn't do individual voir dire. But part of what is in Exhibit 2 is a demonstrative of all the known times Lucky Ward was not present and there was no voluntary waiver. And that includes parts of voir dire. And I've had some, there's differences in our briefing about how many jurors were excused.
So we deviated, getting back to my original
Yes.
question, was there ever a competency hearing at any point before or during the trial?
During voir dire, there was this pseudo drive-by competency hearing where over the weekend, she
Yes.
sent in a conflicted expert who admitted on Monday morning, he'd not yet reviewed records. He'd just been given some records from the jail that morning. He had never met with Lucky Ward, but he was willing to say he was competent based on talking to some jailers. That was
Okay,
it.
okay.
There was
hang on,
no
yes.
examination.
Imagine that is you on trial, or some family member, and they're asking a jailer, do you think he's competent or not? Well, yeah, I think he's competent. Imagine that. This is horrible. This should have never happened, and every one of the people involved in this case needs to have their license looked at. They need to be looked at. So improper. So improper.
By the defense or even the state. Meanwhile, the defense had also obtained funding to get their own expert appointed. And he had not yet, he wanted to, he was not able to appear in person. He asked to appear telephonically. The judge denied.
Because I've participated in several competency hearings. You stop the proceedings, there's a judge, whether it's the trial judge or another judge is referred to him. There are witnesses that testify, and after it concludes, then there is a finding of either competency or incompetency. Did that ever occur in this case?
What Judge Bradley concluded after there was one witness, the witness who never met with Lucky Ward, and then the defense was not able to put on their expert because he had not either had a chance to meet with Lucky Ward. So on Monday morning, she asked the defense, are you willing to proceed? And they say, well, we are, essentially waiving the competency inquiry. And then she pushes them to say, well, do you think he's competent? And they say, they sort of talk around the issue, but they say he's competent to decide not to testify. And then they put on the record a whole bunch more evidence he's not really competent during the course of that day. He's not there in the morning proceeding, and then they bring him back at some point, and he's drugged so much, they put on the record that he's falling asleep and he's not able to talk to them.
I guess the answer is no.
Damn.
The answer is no. It's just, Your Honor, and I apologize for all the complexity. I think Judge Bradley believed she had made a finding of competency, but there was never really a full hearing, let alone the formal trial that the statute mandates, as this court recognized in Blunson, that once you acknowledge there's some evidence and you appoint a psychiatrist or psychologist or a mental health professional who's qualified, once you make that admission, you have to follow the statute, mandatory that you end up with a trial unless both parties agree that the defendant is incompetent. And that process was not filed, and it's mandatory. And back to your question, Judge Yank, this all stems from decades-old Supreme Court law that says there is a substantive constitutional right not to be tried while incompetent. And the reason is because there is a fundamental right to be present and confront those who accuse you. And if you are mentally incompetent, you're being deprived of your right to be present. So this goes back to Dusky, Pate versus Robinson. And what the Supreme Court dictated to states is you need to come up with adequate and fair procedures, due process, to protect this substantive federal right. And Texas's solution to that is Chapter 46B, and quite the admirable state law that shows judges what is mandatory to protect due process. So Mr. Ward didn't get that. He didn't get the due process, and therefore we have no way of knowing this substantive right not to be tried while incompetent was robbed. But we have a lot of good evidence because he missed most of his death penalty trial.
We did have a question, though, as you pointed out a minute ago, to his counsel from the bench of, is he competent? And the answer, The judge asked his counsel, is he competent? And the answer she gave was yes, right? So
The judge
what's-
asked-
What's triggered as against that backdrop? I understand the chart and best practices are to follow the chart, but what's a judge to do when the judge asks the right question and gets the answer from his counsel that he is in fact competent?
Two things, Your Honor. First, we look back to Drope, one of those seminal Supreme Court cases on competency. And in Drope, the Supreme Court makes clear that while you need to rely on counsel to inform you as a judge, you do not abdicate your responsibility as a judge ever to ensure the defendant is competent. And that's why in Drope, we had a similar situation of a defendant attempting suicide during trial. And the argument was, well, that he brought it on himself. So too bad, so sad. Supreme Court rejected that. Also, this court in Blunson rejected that implicitly, because in Blunson, same thing happened. The counsel are like, never mind, we take it back. We feel he's competent. We can go ahead with trial. And this court said, no, the statute means what it says. And so judges do not have any discretion to simply ignore the statute that took years and a lot of bipartisan and interdisciplinary work to craft. And I see I'm about out of time, and I never got to 404B. I want to say real quickly that I know Judge Keel is very aware of the analytical process because of Velades that you decided in 2022. Three-prong analysis. None of those were satisfied in this case. There was not beyond a reasonable doubt proof that Lucky Ward had anything to do with Carol Flood's murder. There was also no need on the part of the state that is legitimate unless you overrule virtually all of this court's 404B jurisprudence, because identity of a perpetrator using an extraneous to prove that requires nearly identical fact patterns. We don't have that with Rodriguez and Flood.
Where's the harm there? It's happening in guilt innocence, right?
The
evidence is coming in. It is odd to me that you would have an unadjudicated prior bad act with something potentially less than preponderance of evidence tying this defendant to that act. So the harm for the other two, frankly, to me seems fairly low in terms of guilt or innocence, but there's a high risk that error, if it's error, washes over into the punishment phase, where you have an unadjudicated, unproved additional murder, potentially, that was put in front of the jurors during the guilt innocence phase.
And Your Honor, if I
Where's
may,
the
I think
harm?
I'm
Go
out
ahead,
of time, if I may respond.
Yeah.
I think the harm is actually far greater in guilt innocence because there was such insignificant circumstantial evidence linking Mr. Ward to Rodriguez, and then virtually no competent evidence, really none, that he was responsible for Carol Flood. So by injecting that, you blind the jury. And as this court said in Ridgely, an extraneous murder in the guilt phase, the prejudice is almost self-evident. It certainly had very little probative value. Carol Flood's tragic demise doesn't get you any closer to proving who killed Carlos Rodriguez, because there's nothing in common in the two crimes.
Before you go, what do you see as the threshold, let's say a conditional relevance threshold under 404B to get evidence of the other strangulation because of the fact that he'd given her the scarf, to make it probative of anything relating to the other murders? At a minimum, does there have to be proof by preponderance that he did the unadjudicated, uncharged murder? Does it have to get to that level before it should be admissible?
What you're
Common scheme or technique?
What this court has said over and over is there must be proof beyond a reasonable doubt of the extraneous. So that's first, you got to prove that. They did not satisfy that. And there's been a lot of loose language about DNA in this case. There was not DNA, there was YSTR results from a mixture involving at least 3 people, including 2 males. How do you even do YSTR testing when you have 2 males? I don't know. But that was what they had on a scarf that had multiple people's DNA all over it. It was a scarf a homeless woman had. Who knows where she found it? It's found in the streets of Houston. I'm telling you, I touched this podium. I may leave my DNA here. Opposing counsel comes up, touches the podium. She may take my DNA and then go back to Houston in her car, leave my DNA on the steering wheel mixed with that and her kids and whatever. That doesn't prove I was in her car. The scarf is not dispositive of anything. And plus, there was multiple DNA on that scarf, multiple people in a community of homeless people where Lucky Ward plainly, he was sleeping in the streets, as was Carol Flood, going to the same shelters. It's not at all proof of guilt of a
There
murder.
are a lot of also a lot of similarities between these. I mean, sort of similar time frames, similar places, similar manner of death. A lot of
No.
other, like sexual things going on right around the time of death. So there's a lot of beyond the DNA, right? There's a lot of other facts that seem to connect these murders.
And Judge Erie, we would respectfully disagree in that if you look at the facts, and there's a summary in a demonstrative.
Right, for just a moment here myself. No, it is not the same. They were not similar. They did not even have the similar type of injuries that caused the deaths. And let's talk about this YSTR DNA for just a second so everybody understands what this is. It's the Y chromosome short tandem repeat. That's the type of testing this is. And it identifies mixed samples. However, the limitation is all males in the same paternal line share very similar profiles. This means it cannot identify one specific man. It can only say this DNA matches this male line, not the exact person that did it. So it's really, the bottom line is it just tracks male lineage only. It is only used for including or excluding groups of men, not an actual person. So here we go.
Exhibit 3 of the basic factors of the Rodriguez case and the Carol Flood case. The only similarities in this, and the state really had to stretch at trial and talk about strangulation in Houston. Like this isn't sufficient. This isn't what is in this court's 404B cases. They're signature crimes.
What is the full time frame from the earliest murder to the latest murder?
Mr. Rodriguez died on September 15th, I believe. And Rita Long, September 30th. And Carol Flood was, I think, October 10th.
So
But
it's like it's less than a 2-month period of time. I mean, less than a 2-month period of time of all these strangulation murders. How many strangulation murders happen in a year
Well, and
in
this,
that same area of town?
Good question.
and Your Honor, that is an excellent point. And one of our other
excellent.
points of error, clearly not designated for day, is about how the defense was deprived of a chance to put on that very evidence. They had obtained a spreadsheet from the Houston Crime Lab of all the strangulation deaths in the Houston area over this period, including all the years Lucky Ward spent in jail. And there are numerous ones. And if you start reading the 404B cases out of this, you find strangulation is not an uncommon, unfortunately, way for someone to die.
Counsel, quickly, very quickly. Why would these be generic instead of signature?
Your Honor, in the CCA case law, if you look at them, it's like even having the semen of a perpetrator in a victim in 2 different crimes has been seen as insignificantly similar, even when these were both women who were assaulted in the same town. And Mr. Rodriguez died, we know, of strangulation, and the autopsy report suggests it was neck compression because there was very little trauma to the neck. There were some red spots on his neck when his naked body was found after his roommate reported he had had a sexual encounter with a bald, muscular black man. Miss Flood was a 60-year-old African-American homeless woman who died from ligature strangulation with a lot of violence. There was trauma to her head. There was trauma to her vagina. She was half naked. Very different crimes. This is not signature handiwork Mark of Zorro, the kind of language this court has utilized in these identity cases where 404B has been seen as appropriate.
Let me just say this. Okay, so 10% of all violent deaths are strangulation. So if you look at all the violent deaths in Harris County or Houston, Texas, and only 10% are strangulation. Are they trying to tell us that this guy is responsible for all of those because maybe they're all the same? This is the most ridiculous argument, but we'll keep listening.
Okay, counsel, I think we have that argument. You have some time for rebuttal. We'll look forward to
Okay.
hearing from you.
So sorry, Your Honor. Thank you very much.
Good morning, please the court. My name is Patricia McLean with the Harris County District Attorney's Office, and I represent the state in this case. I'm going to jump right to the extraneous issue since that's the last topic you all covered. The trial court did not abuse its discretion in admitting evidence of Carol Flood's murder in the guilt phase under Rule 404B and 403, but the focus, since y'all focused on 404B, I'll start there. First, the trial court properly did find that any rational jury could find that appellant murdered Flood beyond a reasonable doubt. And to your next question, that is the standard. Is the question that the reviewing court asks is, yes.
And you said that this could be beyond a reasonable doubt.
Yes.
How?
Okay. Are you saying that some jury may do it? Are you saying that this is really evidence beyond a reasonable doubt? Because I can't see that.
Thank you.
I'm saying both. The standard for review, as you all know, admitting an extraneous is under an abuse of discretion standard in the first place. So there is some deference to the trial court's findings on this. And the necessary question is, would a rational jury have necessarily entertained reasonable doubt in finding appellant murdered Ms. Flood? And that's not the case here.
Is it any rational jury or just a rational jury? Because a lot of juries aren't really rational.
The standard, Your Honor, is any rational jury, Your Honor.
What we need to review that, and what was there to support that conclusion that we could cite in our opinion if we were to agree with that?
Yes, Your Honor. First, which I'll touch on earlier, the DNA mixture on the scarf. Mr. Ward cannot be excluded as a possible contributor to YSTR DNA mixture on the scarf. And it's important.
Didn't he give her the scarf?
He actually, that's one of my other points, Your Honor. He, at first, when Officer Cisneros was interviewing him, appellant said he didn't know Carol Flood. He didn't know anything about this. He didn't remember anything about it, didn't know anything. And Cisneros went to go find a better picture of Ms. Flood to see if appellant could recognize her, which he was unable to do. When he came back, appellant asked to look at the same picture Cisneros had already showed him. And at that point, he admitted, yes, actually, I do recognize her. And he admitted that he gave her the scarf at some point. And back to the DNA.
And counsel, how many days did the state spend telling the jury about this extraneous murder?
There was one full day of testimony, and then the following day, Officer Cisneros, there was brief testimony from him about appellant's confession or his interview about Flood's death, and also he also testified about the similarities between all three of the cases. So a little over a day.
At least one full day and part of another.
Yes. Out of a 7-day trial, yes, Your Honor.
Yeah, and when you say a 7-day trial, that's 7 actual days. So you're saying there was 5 days of testimony that wasn't related to this.
I'm saying there's more than 5 days. That's unrelated. There's 5 and some change. And there was also an extraneous offense hearing an additional day, but that was outside the jury's presence on this case. They had a full hearing to see on the admissibility issue of the extraneous, Your Honor.
And wouldn't you think that spending more than a full day of testimony on an extraneous offense is a little overkill?
No, Your Honor, I disagree. And that to the 403 point about consuming an inordinate amount of time, this court has held, I believe it was Page, or Lane, I apologize, it's in my brief, that essentially spending a little less than 1 day out of a 5-day trial was not an inordinate amount of time to spend on an extraneous. So this was about roughly about the same time. It's about 1/5 of the entire trial. It was about 1/5 of the entire record. And much of the evidence, it was the same type of evidence. There's a lot of DNA evidence for all 3 of these victims. And Cisneros and the DNA analyst, Robin Guidry, testified to the instant offenses as well. So there was repetition of, it wasn't all new witnesses, that kind of thing.
And it isn't true that the state waited till the very end of question and answer to get into extraneous.
Yes, it was after the state presented evidence of Ms. Rodriguez's murder and Ms. Long's murder. And at that point, they moved for the extraneous hearing due to defense counsel's cross-examination and the evidence that they admitted, their own affirmative evidence admitted that raised the issue of identity in the Rodriguez case and lack of accident or mistake in the Long case. And then that's when they had the hearing.
The very last thing the jury got to hear was this extraneous offense, which was a murder.
Yes, Your Honor, it was another murder. It was prefaced before the jury heard anything. The trial court gave a limiting instruction as to both, as to how it should be applied, that it needed to be found beyond a reasonable doubt, of course, before it could be considered at all. And if so, only for those specific purposes for each of the charged victims. And then that same limiting instruction was given in the jury charge as well.
When you were answering letting Judge Shank's question a moment ago, I was gonna.
Let's stop for just a minute, because look, in this case right here, we're going to talk about this. This DNA problem, this YSTR DNA, this talks about a paternal line, but it cannot identify a specific person, period. Now, why this matters in this case, there's no autosomal STR match that uniquely identifies Ward to be the person, that took Flood's life. They used other murder cases that people who were strangled. So because other people were strangled, then he must have done it too because he strangled somebody. This is unfair prejudice, and I'm very disgusted that this is what happened in this case. But we'll keep listening. Just want to explain that for a second.
Try to track what you said because I think he asked you what evidence would convince us beyond a reasonable doubt, and you began by saying there's some DNA.
Yes.
And beyond that DNA evidence for whatever value it had, what else was there?
Yes, to get back to that.
Yes, thanks.
Not just that there was DNA that appellant could not be excluded from, but the specific location of where that DNA was. Specifically, it was on the scarf, and it was on a loop that extended from a twisted portion at the back of her neck, which essentially the person who strangled her would most likely be holding that exact spot when he strangled her. So that's an important fact.
But there's no proof.
It's not certain that that's the defendant's DNA.
No, it's not. That's right.
Thank you.
And for the YSTR testing, the power of the statistics are different than autosomal testing. However, what the DNA analysts testified to, even for the YSTR analysis, the combination of YSTR profiles was only seen in their reference database about 0.2% of the African American population they had in their reference database, 0.3% in the Asian population in their database, and 0% in any other population in that database. So it was a low number even for the YSTR statistical power or the results.
And in your opinion, that's proof beyond all reasonable doubt.
No, Your Honor, I'm saying that in conjunction with where the DNA was on the scarf, appellant changed his story about how he didn't know her. And then he later said, well, yes, I did. And he admitted he gave her the scarf. Miss Flood was found in an area near where appellant frequented and where he slept. And he also admitted that he, 5 blocks away where Miss Long was murdered, he admitted that he spent a lot of time with her at that location. However, despite all of that, he told Cisneros that no, he had no idea where the YMCA was. He had no idea where the cross street was, even though it was very near where he frequented, where he slept, and where he spent so much time with Miss Long, where he admitted that.
Counsel, so was there other DNA on the little twisty loop thing you were talking about besides?
It was YSTR mixture for
Okay.
the minor component.
So there
And
were
then
two other
Mixture.
contributors.
It's a mixture.
No, just two males for the
All right,
minor.
so presumably Lucky Ward and then another person we don't know.
But,
Okay.
correct.
And then
Yes.
now I kind of want to shift to the competency issue because
Yes,
it doesn't
of
mean,
course.
it doesn't matter. All the rest of this doesn't matter if he's not competent.
Because he was not competent.
All right. So beyond defense counsel's, I think you two would probably argue about how strong this was, but beyond defense counsel's assertion or belief or whatever you want to call it that Mr. Ward was competent, what is the best evidence that Mr. Ward was competent during this trial?
And that actually goes to your questions earlier. Yes, there was an informal inquiry during the trial. During voir
Informal
dire,
inquiry.
the judge engaged in an informal inquiry, which is the preliminary step when a suggestion of incompetency is raised. That suggestion of incompetency was raised during voir dire. That was the first time a suggestion was raised.
Oh my
It was by the defense attorneys. They requested a competency eval in the middle of voir dire after appellant refused to come sit in the courtroom. He was expressing paranoid thoughts. He thought the judge was biased and the prosecutors were coaching the jurors, and he didn't like that there were law students observing.
Okay, you hear all that. You hear that, right? Are you telling me that people cannot see there was clearly a competency problem here? No, you're pulling at straws over here, Miss Prosecutor here. Oh my God.
And he wanted to go back to the jail, and when the judge told him, no, sir, you're going to go to the holdover in case he changed his mind, he went there, and that's when he tied a sock around his neck. And at that point, defense counsel came out and moved for a competency eval.
I have a couple questions on the competency.
Yes, sir. And to get back to that, so after that, the trial court appointed a course expert, Dr. Mahler, to evaluate appellant, and also granted the defense's request to have their own expert evaluate him. Dr. Mahler, appellant refused to talk to him, but Dr. Mahler testified on the following, a few days later. This occurred on a Thursday, and the testimony happened on a Monday. He testified that he reviewed the most recent medical records for appellant. He talked to the jailers who took care of him, and he reviewed the defense's motion and the other information that they provided to him in making his assessment. And after he testified that he opined that appellant was competent, the judge found him so and proceeded with the general voir dire of the next panel. And after that concluded, the defense's expert evaluated him as well. And the following day, the defense confirmed to the court that, yes, he was also evaluated by his own expert as to competency, and they stated they had no further issues. He has remained competent, and they moved forward.
And how long was he in jail before the trial?
It was
10 years?
almost 10 years. He was
10
arrested
years.
November
10
2010.
years.
A lot of things happened during that time that would make a normal person think that this guy has some serious problems. Is that correct?
The main thing that was raised was the motion to withdraw in 2014, so about 6 years before the trial. Former defense counsel Geiser moved to withdraw, and in that motion, at the time, Dr. Mahler, he'd reviewed records, and they had hired him to examine him or to interview him, whatever, as a defense expert.
Mueller reviewed the most recent medical records. He didn't look at all these medical records for the 10 years, did he?
No, he did not.
Thank you.
He doesn't need to, essentially,
Yes, he does.
because the question, the relevant inquiry for competency is your status at the time of trial. So lengthy history, it's not as relevant as the 3 months before, which is what Dr. Mueller did review and consider. So that's the question, is at the time of trial.
He didn't go see him at all, did he?
No, he tried for about an hour and a half to talk to the defendant, and the defendant refused to talk to him. But Chapter 46B does not require that a competency eval include an interview with the defendant. And specifically, the statute actually contemplates that there are situations where a defendant will refuse to talk to an expert, as in the statute, I believe it's 46B it's either 0.024 or 0.025, that the expert cannot base his competency determination on the fact that the defendant refused to talk to them. So it certainly contemplates there are defendants who will not cooperate, and there's other ways to conduct an evaluation.
When you're saying that the defendant refused to talk to him, did the defendant sit in front of him and then tell him he's not going to talk to him, or was this second or third hand information from some jailer that said no, he didn't want to talk?
I am not entirely sure.
He
how it
doesn't-
happened,
she doesn't
but
even
in the
know.
record, he says he tried. I think
No.
they tried to get him out of his cell to talk to Dr. Mahler for about an hour and a half, I believe, is what he testified to, but appellant refused. Is my understanding of the record.
So this tells us the jailer said he's refusing to talk to you. That's what it tells us. Well, let's talk about something for just a second before we go back to this. 10 years, 10 freaking years he waits. This is a long delay. It's an absolute red flag. Absolutely. This is not a complex case. It's a death penalty case, but it's not that complex. Yeah, there was some DNA testing, but mainly, competency, mental evaluations, court backlogs, that can cause 10 years. But this to me seems like something else. It's prejudice to the defendant as far as I'm concerned. Here we go.
Counsel, I've got a question for you.
Yes, sir.
If I understand
damn
this right,
years.
shift back to the 404B for me.
Yes, sir.
The state had to show, in terms of between the Rodriguez and the Flores murders, that the modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature. Would you agree with that?
Yes.
All right. Rodriguez was a 35-year-old biological male, and Flood was a 65-year-old biological female. Just addressing those two, how does that create a modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature?
Yes, Your Honor. And in addressing that, it's important to note that while they need to be very distinctively similar, there is no requirement that they be identical in order to be relevant to identity, to start there. Again, this is an abuse of discretion standard. And the question for signature cases or identity cases is whether the pattern and the characteristics are so similar as you stated. And that includes, as this court said in Segundo, the accretion of small, sometimes insignificant details, including the mode of commission of the crime, proximity and time and location, or any other elements.
Would you characterize gender and age as small, insignificant details?
I would characterize them as details, but it's important to note for those two particular details, number one, they're both adults. This isn't an adolescent and a child and an adult. And as for Rodriguez, she was biologically male, but she was a transgender woman. She identified as female and she held herself out as female. And she even dressed as female, as her friends testified to. And even when appellant met her, when she took their pictures, she was dressed as a woman. Just to those two specific factors that you were talking about, Your Honor. But in addition, for the signature question, considering things like appellant's links. As I stated earlier, he frequented the area near where Ms. Flood was found murdered. And also, it's also where Rodriguez liked to go, the Montrose area where she would go to clubs. And let's see. He also admitted to police that he interacted with both of them. So he had met both of these murder victims before they died. He gave her the scarf at some point, as I stated earlier. And he, again, like Ms. Flood, appellant cannot be excluded as a contributor to DNA found specifically on Rodriguez's neck.
What's the specificity of that cannot be excluded?
For that one, that was autosomal DNA testing for the Rodriguez case. So the statistics were much, much higher than for the YSTR testing, Your Honor.
Can you honestly say, in your opinion, that this sounds like a signature to you?
Yes, Your Honor.
No.
Yes, Your Honor. And the trial court certainly didn't abuse its discretion in finding as much. In addition to the links and the victim characteristics, which I'll get into a little more in just a second, the actual mode of the commission of the crimes is very similar for both of them. Ms. Flood died of ligature strangulation, and Ms. Rodriguez died of strangulation. That was her cause of death. It also included ligature marks, and her death was consistent with ligature strangulation. And multiple witnesses, multiple investigators, and the medical examiner all testified that strangulation homicides are not common. So moving on from there, not only were they both strangled, but they both had fractures to the structures in their necks. They were both found in varying states of undress. Ms. Rodriguez was nude, and Ms. Flood, she was only dressed from the waist up. Sexual activity or assault occurred near in time to both of their deaths.
Oh, wait. Can you direct me in the record where the state introduced any evidence that Flood had recently engaged in sexual activity?
Yes, Your Honor. The medical examiner testified that she had tears to the entrance of her vagina, and he testified that those likely occurred near in time to her death. They were both victims were not found just out in the open. Ms. Rodriguez was found in a duplex that she shared when she stayed there with roommates, and the door was actually left open, so it wasn't left locked and sealed. And Ms. Flood was found next to the YMCA on the stairway that's encased essentially on three sides by a wall and the building itself. So they're not just totally open and exposed to public view.
Are there any similar marks on Rodriguez? I mean, I understand Rodriguez is a biological male, but you seem to put quite a bit of weight on what you referred to as marks around the entrance to the vagina, bruising or tearing. Was there any trauma to the other Rodriguez?
No, Your Honor, but the roommate Sosa testified that when he came down before he left for work, he heard, before he came downstairs, in the hours before Rodriguez was found dead, he heard noises that sounded like oral sex.
So wouldn't that suggest, even under the best
Oh,
of
God.
interpretations for the state, that these two dissimilar or similar, one was a rape and one was consensual? Wouldn't that weigh against the state's?
Right, and I'm not suggesting that Rodriguez was sexually assaulted. It's just there's some sort of sexual activity, that consensual or not, that occurred before their death.
Right, but my question is, you put that forward, the state has put that forward as evidence that these two murders are distinctly similar. But if that evidence is interpreted literally, wouldn't it suggest that one was consensual and one was not consensual,
Thank
weighing
you.
against these murders being distinctively similar?
I think it's going to depend on, number one, you still have to look at it through the abuse of discretion lens, and the context is sexual activity, whether consensual or not. And in light of all of the other factors or the other similarities, which also include there were items missing from both crime scenes. The murders happened less than 1 month. Oh, I see my time has expired. May I briefly? May I conclude, Your Honor?
He says go ahead.
Okay, thank you. Yes, both murders occurred about 27 days apart. And both of these victims, the last factor of similarity between the victims themselves is due to their life circumstances, their lifestyles. They were more prone to encounter people that they did not know very well, whether by bringing different partners home, as Rodriguez did, and she didn't have a consistent living situation. And of course, Ms. Flood, who was homeless as well.
So one of the things that is occurring to me is that all of these individuals, and correct me if I'm wrong about this, because I want to know whether I'm wrong about this, but it seems like they all had interactions with the defendant.
Yes.
I mean, there was a confession to killing Long. There's an indication that Rodriguez had interacted
Yes.
with the defendant, and there's also an interaction with Flood, right?
Yes.
Because he admitted that he knew her and maybe gave her a scarf.
He remembered her. He admitted he gave her the scarf at some point. Yes, Your Honor.
So this is just maybe an off the wall question. That's just something that I've remained curious about for a very long time, which is, have you ever heard of the doctrine of chances?
Yes, sir, I have.
And so I'm wondering, is that real? Is it something that courts can draw real conclusions from? And if it is true that they could, then what applicability would that have in a case like this? How would we rely upon that, if at all?
Yes, Your Honor. The doctrine of chances, it's very similar essentially to an identity case or an identity issue, because it basically the underlying question is, what are the odds that this would happen with the same person and same involvement? Although the doctrine of chances is not specifically in 404B, this court's already stated that it's not an exclusive list. There's other ways that you can get into 404B extraneous evidence. And The few cases I saw in Doctrine of Chances, it also required a very high degree of similarity to get in. So
So we're looking at the same kind of analysis.
essentially, it's the same. They're just so similar. They share so many significant similarities, and it's not a matter of picking one or two at a time. It's looking at everything together, which this court said in Segundo you look at when you're analyzing for
totality.
a signature analysis.
Thank you very much.
Thank you.
Wow.
Thank you, Your Honor. If I may start at Segundo, because the state mentioned this case several times. This is a capital murder case in which the primary offense was a rape murder in which the defendant's semen was found in the vagina of the victim. And the extraneous offenses were rapes in which the defendant's semen was found in the victims. And this court, in a very reasoned decision, was careful about the fact that with this kind of identity use of extraneous, that kind of DNA is like the mark of Zorro. Single source male DNA from a biological substance that was very inculpatory. That is not what we're talking about in this case. And there's been a lot of loose language here with Carol Flood, this YSTR result that the state's own expert, and they spent about 5 minutes on this. She said, this is a last resort. There was very little discussion about what this is, but it was a mixture of 3 or more people, including 2 males. It was not a mark of Zorro. Also, the scarf business. The only evidence that Lucky Ward gave her this scarf, and that's not even what was said, was Detective Cisneros said that after he turned off the video, Lucky Ward said, let me look at her picture again, and said, maybe I saw her at a homeless shelter. And maybe I touched something. That's what he said. He didn't say I gave her the scarf. This was speculation. And this also is hearsay coming from the detective who admitted, well, he could have turned the recording back on. He'd spent hours recording Lucky Ward and he didn't. But it's not inculpatory.
But is the giving of the scarf the issue, or is the DNA on the back of the scarf more
And
the issue?
again, Your Honor, it's not a single source male profile. It's a proof that a male with a Y chromosome cannot exclude Lucky Ward's 1 chromosome. But there's another male in that mixture, and this is really sketchy stuff that they spent years trying to come up with. It is not beyond a reasonable doubt. And, back to your very smart question, none of this matters if he was incompetent.
I have a question for you along that line, because I agree with Judge McClure. What does the record reflect to show that there's some evidence at the informal inquiry of the defendant's mental illness?
Your Honor, he first of all tried to commit suicide in the holding cell after he goes into this rant based on his paranoid delusions that the judge is in cahoots with the prosecutors and secret bloggers in the jury box and text messages being sent to them to tell them how to answer. He goes into this rant, and either the state is suggesting that was totally rational, or that's a significant indication the man was not competent. And then he spends most of the trial back in his little jail cell where the judge sends the guards to videotape him. If you look at these videos, you don't see a man who is rationally equipped to engage with counsel or potentially testify. You see a guy out of his mind. And this is why Chapter 46B exists, is so lawyers don't have to try to figure this out. They can get help from professionals. This appointed expert was conflicted. He didn't provide a report. He wasn't even clearly qualified. And he went in over the weekend and they couldn't get Lucky to calm down.
Well, how could you get better? What psychologist are you going to find to treat the person in order to make them competent in order to stand their capital murder trial?
Your Honor, that's an excellent question. And 46B has a lot to say about that. That part of what's supposed to happen is everybody pause, you get the truth, and if you have an incompetent person, there are procedures for restoring competency so that they then can actually be tried in a constitutional proceeding and not something that makes us look like a kangaroo court.
Do you feel like that the defendant's mental illness interfered with his ability to
Absolutely.
participate in this trial?
Absolutely, Your Honor. And this is not this, the defense itself ended up putting on in punishment a mental health expert who described Lucky Ward's long, well-documented serious mental illness of bipolar, schizoaffective disorder, schizophrenia. These include diagnoses made by TDCJ, by the jail, long history going back to his teenage years.
To establish his incompetency?
No,
Why not?
no, because his lawyers, I can't say, but it looks like they were exhausted. They got a hostile judge who wanted to move forward, said that over and over, and they gave up. It was too difficult to deal with their incompetent client. They just wanted the trial over.
Have you challenged counsel's effectiveness in this?
Your Honor, I have not, because it doesn't tend to be successful in direct appeal, but I suspect that might be something that's coming later. And Your Honor, if I may, one statement about the 404B. I know you're going to do a legal sufficiency review. It is very important not to play fast and loose with what the evidence actually was. Again, the only single full male DNA profile from which Lucky Ward could not be excluded that was introduced by the state was DNA lifted from the passenger door of Charlie Rodriguez's car. And that is completely consistent with what Lucky Ward himself told police about how they had this interaction in a parking lot in Montrose where Rodriguez was going out clubbing and Lucky Ward, homeless guy, was trying to hustle for a tip and said, "I'll watch your car." It's not doctrine of chances. This court's great opinion in Delaz Paz talks about that doctrine. It has to be, again, virtually identical. And again, in that case, you had a buy or bust drug setup situation with a cop where there was no doubt that the guy had done it multiple times. And then in this trial, they wanted to introduce it because yet again, same pattern. This is not that case. Thank you, Your Honor.
All right.
The case will now be taken under submission. I'm going to ask if we now have in the courtroom Cheryl Dixon. Is she here?
Okay, so that is the end of the oral arguments for Lucky Ward. Now, let's talk about Lucky Ward for a minute. Now, they talked about doctrine of chances. Okay, so doctrine of chances and the Rule 404B and how they intersect. All right, you can't use prior acts to say he's just a bad person, but you can use them to show intent, identity, absence of mistake, knowledge, or pattern. Where the doctrine of chances fits in is basically the theory that that justifies admitting 404B evidence. It's like saying, pretty much like saying, that 404B opens the door for the doctrine of chances to explain why it should be open, right? So it's just the reasoning that makes it admissible. Like, we're not showing he's a bad person. We're showing this isn't a coincidence. Now, in my opinion, and I know a lot of people who watch true crime with us, and we go to all the same chats, and we watch all the same other YouTubers. We talk about there is no coincidence in crime. There's no coincidence in crime. There's just not. So I'm going to have to disagree with the state on this, and I'm going to go, in my opinion, he's going to get a new trial. I feel like he was completely incompetent, and the way they went about this 10 years, that's a huge red flag. Sprinkle, tell me what you think. Right there? Okay.
Hold on. I thought I was
Okay.
muted. Yeah. I mean,
Okay.
I know COVID was involved during this time, but that's still no excuse. They're just it's just all a bunch of BS to try to make this go away. And and it shouldn't, it's not fair. If it was somebody else, like you say, if he was a white man, this wouldn't have happened. And it just seems to all be so black and white. I don't understand what all the problem is with getting this man what he truly deserves. I mean, this is the United States of America, for God's sakes. This stuff should not be happening.
I mean, he admitted to the murder he did. He admitted to that one.
Yeah.
No problem.
Yeah.
He told the truth. He admitted to that. Why in the world do you want?
Absolutely.
I don't understand them trying to just blame two other ones on him because, they're just unsolvable. Just throw it on him, and that way our case records are good. We've solved all the cases. Hell no. That's not how it works in America. It's very disturbing.
And how was it all allowed? How was all of that quote unquote evidence allowed to be presented to the jury? Because it's not even evidence.
Because the judge that was overseeing this trial was already biased and prejudicial and just didn't want to mess with it, because you have an incompetent defendant who's not even in the courtroom to watch his own trial or say anything about his own trial. They just want to get it over with. So she's
and then you have stupid ass people like Letitia, who's obviously freaking guilty, and she's getting a new trial. I mean, it's just sad. I mean, this man's life is over. You know, I mean, he's never gonna get the care that he deserves. He's never gonna get the medical care or just the physical care that he deserves. I mean, his life is done.
You know, they have not made a formal opinion yet. I'm going to be watching for this opinion to come out. It should come out soon, because this was actually back in, I forgot what date it was. Was it March 15th or February 5th? Remember. Anyway, it should be coming out soon. I'm going to be watching for this opinion to come out. And as soon as this opinion comes out, we're going to have another live and we're going to talk about the opinion and see what happens. I'm going to say that I really do believe he will win a new trial because of the incompetency situation. He was clearly incompetent. Everything should have stopped, and they should have gotten him, brought him back to competent before they had the actual trial. And I realize it had already been 10 years, which is damn ridiculous and a huge red flag, but it still should have stopped. It should have stopped. So, with that being said,
it's just so not right. So not right.
It's so not right. Well, I hope everybody enjoyed listening to our show today and with our discussion on this Court of Appeals case and Mr. Lucky Ward's case, and just shows how a person can be treated when they don't have the ability to pay for the type of attorney that they really need to protect them when they've done something. I mean, he admitted to what he did. He should have been tried for just the one case instead of them lumping a bunch of other shit on him just because they could. So with that, I'm going to say goodbye. Have a wonderful afternoon. We'll see y'all tomorrow, maybe. And as I always say, be careful out there. Take care of yourself and go ahead.
And hug your babies. Hug your babies.
That is damn right. Life is short and our time with them is even shorter. And with that, I'm going to say good night and we'll see y'all later. Thank you so much. Please hit that like button.
Good night, everybody.
Thanks.